2 weeks out. My next date is not till 2 weeks out.
Okay.
So I'll adjourn the matter to April 10th, 2026 at what time? 2 p.m. That's an in-person proceeding. Okay, you can file Zoom request forms, given that I think everybody here is a corporation, but those are typically an in-person proceeding.
Okay, so that's April the 10th at 2:00 p.m. in person. Otherwise,
Yeah.
we can file a Zoom. What was that, request, or what did you call that?
Yeah, a Zoom request. However, I'd have to decide whether or not I'm going to grant it. I may make you all come in.
Okay.
Did you say 2:30 or 10:30?
2:00
I said
p.m.
2 p.m.
Oh, 2 p.m.
2
Okay,
p.m.
got it. Thank you, Your Honor. I'm sure once Mag retains counsel, we can talk and see if we can agree to do via Zoom. But if you want us there in person, happy to obviously come in person as well.
All right. Very good. Okay. Thank you, folks.
Thanks, everyone.
Thank you, Your Honor.
Good morning. Redford West versus Mary Cheatham.
Good morning to you, Judge Simpson. This is Attorney Paul Spaniello. My P number is 72366, and I'm here on behalf of the plaintiff in this matter.
All right. Mary Cheatham?
I'm here, Your Honor. I'm trying to put my camera on.
Gotcha.
Can't-
Okay, well, did we get her? No. All right. While you do that, counsel, this is a non-payment of rent case. What's the plaintiff's claim, including cost?
The amount, including costs, is $6,158.00. That's January through March with court costs.
All right. And Ms. Cheatham, we've got a picture now, and if you can unmute.
Okay.
Okay, there you go. All right. How are you intending on trying to get this paid?
Okay, so this is the deal. I've spoken with Ms. Shifter because this has been kind of a complicated process. It was a possession case. I don't know if you remember. I was in here maybe a few weeks ago. It was initially a foreclosure, and then I had signed a lease. And speaking with Ms. Shifter, my intent is to vacate, and there was some discussion about possibly avoiding a judgment. I have reached out. I have some help coming my way through a place called Here to Help organization. They help people that were incarcerated with funding for new places. Basically, my intent is to vacate. It was waiting for my inheritance to come through because the thing, I have the money to pay the back rent. And if I do that, then I don't have money to move. And I don't think that they want me to maintain or remain in the lease is the thing. So they just want the property to vacate.
Okay. So if I adjourn this out a couple of weeks, you guys think you can get that all solved, or?
I think so, because my intentions are to be later 15th. It'll probably be sooner than that, but
Judge?
Counsel?
Thank you. If nothing else, I'd like to make a record. Your Honor, you may or may not recall, we filed this case late last year as a termination subsequent to the expiration of the redemption rights. We did a termination. You dismissed the case because my client executed a lease because Ms. Cheatham advised that she wanted to stay in the house. She tendered a payment, which subsequently was reversed as NSF charges. The court advised the parties that this had to come in another manner. So we filed a non-payment case. Respectfully, this story about moving out has been going on since, I don't know, late quarter of 2025. So I frankly find that this explanation is intellectually just disingenuous, Your Honor. So if Ms. Cheatham was going to move, I mean, we've been asking since late last year when the termination was filed. And then when the payment was made, when the lease was executed and was reversed, it was clear that she wasn't going to stay there. So And Ms. Shifter has not advised me, or my client has not advised me of any agreement whatsoever. None. Zero. That's why we're back here, Judge. So
Who, Ms. Schichter, help me, who is that with
she's
reference to these parties?
she's a representative of the client, of the plaintiff.
Got
She
it.
was here. We came in an in-person hearing that resulted in a default judgment. I can't remember the exact day. If it's of any importance to you, I can find it. But we got a default judgment. Ms. Cheatham filed a motion to set aside the default. You granted the.
No, I recall.
Okay, I'm sorry. I don't need to go.
No, it's okay.
Thank you.
It's okay. No, I recall because it was certainly an unusual circumstance.
My client made
it's
an
all
error.
coming back.
No good. This is classic. No good deed goes unpunished. There was a lease executed. Ms. Cheatham advised that she wanted to stay in the property with her family's property. My client did that. They signed the lease. Guess what? The payment was reversed, but the court felt, well, counsel, your client has a landlord-tenant relationship now. Well, here we are.
Yep.
January's not been paid. February's not been paid. March has not been paid. And now we're being told, oh, we need time to move.
Well, here's the thing. It's now filed as a non-payment of rent type of case. If the parties can't work it out, but she would be entitled to an adjournment of the proceedings. How much is monthly rent on this?
Monthly rent is $1,900.00, Judge.
19?
Yes, 1,900.
May I respond to Mr. Is it Spaniolo? I spoke with Ms. Shifter, I believe on the phone. It was I think it was the Friday before last. And I advised her that I was trying to get into contact with my lawyer to get a definitive timeline of when my inheritance might be coming through. But that's neither here nor there. My intention in the first place was to stay in the house, and unfortunate things happened. And I don't know if you remember, it's neither here nor there. The money, I had it, and then something happened and it was gone. So at that point,
all right. Here's what I'm going to do. I'm going to reserve the issue of escrow because I can't order it at this. She would be entitled to an adjournment in any event, this being a non-payment of rent case. I don't have a week out. I do have 2 weeks out. So I will adjourn this to April 10th, 2026 at 2 p.m. That is an in-person hearing. And given everything, I think I'm going to want all the parties.
Understand that. Forgive me, Your Honor. You said April 10th, correct?
Yes, April
Okay.
10th, sir.
At 2 p.m. Thank you, Your Honor.
Thank you.
Have a good day.
You do, sir.
thank you.
Babu Bandapati, versus Melody Sittenhelm.
Good morning. Hello?
Who is that? Check in.
Hello? I'm online.
State your name, sir.
This is Babu Bandapati.
Okay. And we do not have the defendant to pay for a second mailing. No second mailing by the court. All right. Why do we have? All right. Okay, sir.
Yes.
I don't have the defendant here. You did not pay for a second service, so I can't take a default. The only thing that I can do is adjourn this out to my next hearing, noting that the defendant hasn't appeared at this time.
Okay. Just a side note on this one. I think the defendant needs help. Currently, she was on Section 8, just a backstory here. And basically they cut her payment and she has health issues currently and she doesn't know where to go. She's thinking possibly hospice. Not so she's really kind of at a situation right now, crossroad, where she can't stay in the house because the power is going to be cut off and everything for non-payment, and I'm concerned about her health right now.
Got it. I hear you. Okay. Not sure there's much we can do at this point. All right. I'll adjourn it out to April 10th, 2026 at 2 p.m.
Yes.
At 2 p.m.
Okay.
And maybe she can get somebody repetitive or somehow or another communicate with the court regarding where she is on this.
Fair
Okay?
enough. Fair enough. Thank you, sir.
Okay. Thank you, sir.
Yeah.
Joseph Getz versus Joshua West.
Morning, Your Honor.
Okay. Mr. West, I'd appreciate you not smoking.
Yeah,
All
yeah,
right.
no, I'm not.
Okay. All right. Mr. Getz,
Yes, Your
what
Honor.
is your, yes, what is your claim in this case?
So he hasn't been paying rent for the last 2 months. We're approaching a third month without him paying rent. I tried to serve a notice to vacate on the first month and I didn't use the right paperwork. So I served a 7-day notice to quit.
Okay. So, sir, how much does he owe?
At this current moment, $1,400.
All right. Then you've got costs, it looks like here, about 87. All right. Sir, Mr. West,
Yeah.
how are you intending on getting this paid?
Well, what happened was when I moved here, I didn't have any money. And I've known this guy since like first grade. He told me it was cool. And I got 2 jobs and I started paying the rent. And the rent wasn't, there was never any lease signed or anything. I never got, but the deal was that when I started working, I didn't have, it was like, I'll give you the money when I get paid. And in January, I paid him on the 23rd. And then in February, he got all drunk and started freaking out and told me he was going to throw all my stuff out and started putting my stuff in boxes and throwing my food away. That's why I didn't pay the rent. And I would have moved out if I had anywhere else to go. But
All
I
right.
don't have anywhere else to go. So
Do you have, this is a non-payment case, so do you have the money to pay?
no, not now. I don't.
Okay.
Yeah. I moved in here and this guy told me he was on felony probation and he wasn't drinking. And then he's drunk every day going crazy. And I ended up getting fired because I didn't sleep for a week dealing with this. Like
Okay.
it wasn't like I just didn't pay the rent. Like I'm trying to get it
All
together
right,
and get
here's
out of
what I'm
here.
gonna do. Second service wasn't paid for. What I'm gonna suggest.
I don't know
that you
I don't know what
accumulate-
that means. I don't know what that means.
There's not a second service by the court, which means I can't take a default or do anything today. I'm going to adjourn this out. Mr. West, if you think that you need an attorney, and for that matter, Mr. Guest, if you think you need an attorney, that'd be your opportunity to hire an attorney. We'll adjourn this out to February, to April 10th, 2026 at 2 p.m. That's an
2 p.m.
in-person hearing. And I'll need you both down here at the courthouse. All right.
You said April 10th.
Mr. West, April 10th, 2 p.m. Mr. West,
Okay.
in the interim, what I'd suggest you do is accumulate what funds you can when you come down, because I think Mr. Getz is probably correct. Another month is going to click in by the time you get back here. And so there's going to need to at least be a payment while you guys try to work this out. All right.
I would pay it if I had the money. I don't have the money. It's not that I wouldn't pay it. I've been trying to find a job.
I hear you. What I'm indicating though is that you said you had jobs.
Not
So-
anymore. Not anymore. All my
Because you got fired.
yeah.
Okay. Well. Okay. So we'll see you guys down here April 10th, 2 p.m.
Thank you,
In
Your
person.
Honor.
Okay.
All right.
Do
Thank
I have to do anything else right now or?
Well, if you want to hire an attorney, you can, or if you want to seek assistance, you can call the numbers that were on the slideshow at the very beginning. You can
Okay.
call Hawk. Did you get that number?
No.
All right.
I
You
saw-
got some? Do you have something to write with?
Hold on one second. I do. Okay.
They are 961-1999. That's area code 734.
734-961-1999.
Yes, sir.
And what was it called again?
It's called HAWC. That's an acronym. It's HAWC. Housing Access for Washtenaw County.
Okay, and you said April 10th at 2 p.m.?
Yes, sir. In person.
What, is that just Saline Courthouse or like to get
No,
directions?
you're gonna come to the courthouse I'm at, which is the one by the sheriff's department.
What sheriff's department? In Saline?
Washtenaw. No. All right. You know,
I just moved here in October. I'm not from, I don't know
okay,
where
no, I got you. I'm just trying to explain it to you.
Yeah, I'm not trying to give you a hard time.
Sir, I'm just trying to tell you how to get here.
Okay.
The address is 4133 Washtenaw Avenue.
Okay.
Okay, and it's right off of US 23.
Okay.
All right. So if you were to just ask or put in your phone the Washtenaw County Sheriff's Department, it'll show you this location. We're right attached with them.
Okay. Well, if I don't get some money, my phone's gonna get turned off. Can I still show up and do this without my phone?
Oh yeah, you can show
Okay,
up.
okay.
I was just saying, use your phone to find the location.
Yeah.
Okay.
Okay. Yeah.
All right. We'll see everybody April 10th.
Thank you, Your
What?
Honor.
Okay. Thank you.
All right. Thank you.
Do I just
That's
hang
it.
up now?
Yep. Hang up.
Okay. Okay.
You're
Thank
good.
you.
All right. Okay. Court's in recess.
Was all to work. And for most people, that's very important. You can drive to work, school, treatment, court, other limited purposes, as opposed to an outright suspension. You understand?
Yes, sir.
Now, the other charge will require the forfeiture of your gun or guns. Do you understand that?
Yes, sir.
Did anybody threaten you to get you to plead to this charge
No, sir.
or promise you anything?
No, sir.
Do you understand that by pleading to this charge, you'll be giving up all the rights that you indicated there on your advice of rights?
Yes, sir.
Now, I see some promising things that your lawyer has given me. You're connected with Pivotal, and that's a plus. And looks like you're plugged into the Vicksburg AA group.
Yeah, I've been doing it since February.
Good. I've got a lot of people in our county that like Vicksburg AA, meet 7 days a week at the community center there. Some of my sobriety court folks are going over there. I knew a man, just knew him, and he got arrested and got plugged into Vicksburg AA and really liked it over there. Now you live in Three Rivers, but you've just connected with the AA in Vicksburg?
Yeah, I grew up in Vicksburg. I heard a
Okay.
lot of good things.
All right.
Pivotal recommended it for the moral support.
Well, that's a good start. We've also got some good AA here in St. Joe County. The biggest one is at the Carver Center, but, all right, well, let's talk about this. Let me pull this up. Now, one thing, I'm sure Mr. Gibson told you, if you plead to this charge, I'm not able to sentence you today. I have to set up for what's called screening and sentencing. So we'll pick a day that works for you and your lawyer, get more information about what you're doing before we do the sentence.
If I may give the court some information, the defendant, as part of his job with Ox, he works at Ox Engineer and he's been there over 30 years, and he's actually he has to go on an overseas trip to China, and so he's going to be gone April 9th through April 20th. So we would ask that the sentencing, I guess, works around, I guess, that date period.
All right, very good.
Sounds like a long trip to me.
I've never traveled, so.
Well, you don't do a weekend in China, so my kids have all been there. I have not. Did you live in Schoolcraft at one time?
Yeah, 10 years.
All right, but now you live in Three Rivers?
Yeah. We had a house built just outside of Three Rivers.
Off M60 there?
Right past the airport, yeah.
Okay, yeah.
Right in that cul-de-sac area.
Did you have that little steel one built?
No, I'm behind that.
Okay, not the big steel one. There's a
Oh,
small.
no, that's just around the corner. It's a ranch style.
Okay, there's a cool little small steel one there.
Yeah, my wife and I walked past that the other day. It's beautiful.
All right. On December 6th, in Park Township, out by the dairy farm, did you crash into a barn?
Yeah, I didn't have, I was having a panic attack and I didn't it's a spin knob on my truck. It's different than on the floor. I didn't put it in park, and when I let off, it rolled into it. It didn't do any damage, but.
All right, and how'd you happen to be out there?
Well, if you don't remember. Your Honor, we're asking for a no contest plea because he has a very, I guess you could say, hazy memory about.
All right, well, let's see what we do remember. Were you drinking Jameson?
Yeah, I was.
They gave you a blood alcohol PBT and it was 0.233.
Yeah,
Well, impaired driving is a real gift.
yeah.
And did you have a handgun in the car?
Yes. We've been moving everything out of our storage unit and out of my safe, and I had generator in the back. I had a bunch of stuff, and the reason I was there is it's 2 miles from my house. I just got the Jameson, and wife didn't want me there, and ultimately I drove off without my keys. She's had them, but I drove off and went out there. I grew up on a farm and the cows were nice and there was no one there. And I sat there.
Well, it's stinky out there.
It is, but that's what I grew up on.
All right. All right. Sounds like you need some attention. And I felt like this was a big wake up call for you. And maybe that's all a good thing. You don't seem to have much of a criminal record. I wanted to look at your
No, I've
driving.
not been in trouble before.
Well, then maybe we're lucky that nobody got hurt and we got a chance to. No, for reasons I don't understand, there's not a driving record in here. What address is on your driving record?
Probably
School?
my son was 6, so we're on, so I did get a speeding ticket, I think.
No, but I mean, is your driving record still say Schoolcraft?
Yeah, I had an appointment.
Yeah,
go
you
get
need
it
to change
changed.
your address, because.
I did go in and change it, but they wouldn't give me a sticker. They said, yeah, you know, depending on today.
Well, because any mail, we don't have a driving record in here.
Yeah,
Any mail they send to your address on your driver's license.
I did change it
All right,
though.
very good.
I made an appointment, went to the Secretary of State, and I did change it, but they didn't give me the little
Well,
sticker. I got
and you're in a tough spot because you got a paper license, correct?
I actually got my real one, but I got a paper one with it.
All right, so it's there, because when you fly in an airplane, they want to see your driver's license. Now, you're going to China, so you'll have a passport also. But heaven forbid, if you get arrested for drunk driving right before you have to take a plane ride, you're in this funky paper license business. Anyway, you should be all right.
Thanks for thinking of that. Yeah. Like to come back.
Yeah, they won't let you back in. You'll be stuck in Guangzhou. All right, I'll accept your plea. I have enough facts from you to get the fact that you had been drinking, you were a 233, you were driving the car, and you had a gun. So although you don't have a clear memory, I have enough to accept your plea. All right, well, let's pick a date here. We probably have to go out to May. Paul, are you available on May 4th at 11?
Yes, that looks okay.
Should be warm enough by then. What I'm going to do is I'm going to give you some paperwork to take out to the counter. They will get some information from you, get this for screening and sentencing after you get back from your trip. Now, the bond says you can't leave the state of Michigan. You have the authority of the court to go on this business trip. And kind of abscond and stay in China. So I will note defendant has court permission to leave the state.
Thank you.
Mr. Verwey, I can tell just from what I've seen that you were at a low point here. I see a person that was depressed and self-medicating. So I think we're going to get to a better place. Anyway, there's probably a probation in your future. We'll find out more about this. I'll indicate I need driving record for file. Court officer will take you out. You can meet with the clerk. They'll give you a date to come back for your sentence. That'll be the 4th of May at 11 o'clock.
For the sentencing. The probation department, just to confirm that there doesn't be like kind of little bit of
Hello, Sergeant Herman. This is Judge Middleton calling. I can't see your records anymore. Can you tell me how many jail credit days Elizabeth Conway has? Well, we could just go from the date of her arrest. It's a pain for us, so hopefully we'll get something up that we can get at. All right, I'll figure it out. Well, I wasn't clear, so it looks like she's been there since the 9th. Date of the offense is the 9th. All right, today's the 27th. All right, that would be 18 days. All right, thank you. All right, bye. They can't tell either. This new system, they dismantled the one that worked before they got up to one.
Mobile Patrol doesn't work for us anymore.
What? No, Mobile Patrol is defunct, I think, but we had it's called web jamming. We be jamming. It's shut off and we use it every day to determine who's in jail and who's got issues and do we need a bench warrant arraignment? What's the bond? How many days do they have? All right, are you ready on your case, Mr. Bush?
There's a number of them we can take care of.
Well, let's take care of Pablo, and he's joined us. We have had some issues with sound going in and out. Laura, would you join me now to see if we can see what's going on? John, I don't have this case.
Oh, I'm
Jams. They might have to remote in some settings on Zoom.
All right, that might help.
maybe I didn't get that.
Let me get it from Autumn.
¿Me puede escuchar, señor? ¿Me escucha?
Sí, yo escucho.
Oh, qué bien. ¿Claro o está, o se oye mal?
Sí, claro.
Oh, ok.
Did I misplace on your number?
No, but they didn't know what the deal was. Anyway, we've got the files. We got Pablo's door. All right, everybody, good morning. We are in the thick of it here. We've got a number of pleas we're going to take a result of the pre-trials, and we're in pretty good shape. Miss Abby Stoll is joining us from the prosecutor's office. Appreciate her help also. All right, the matter we're going to address are several files regarding Daniel Gonzalez Jimenez. Is that you, sir?
¿Es usted el señor Daniel González Jiménez, señor?
Sí.
Yes.
You have some cases that were charged under Sturgis City Ordinance
Usted tiene varios casos donde le imputan delitos de acuerdo a las ordenanzas de la ciudad de Sturgis.
and some cases that were charged under state statute.
Y otros casos le están imputando delitos bajo los estatutos del Estado.
You got charged with drunk driving twice.
Le están imputando el delito de que está manejando borracho 2 veces.
In file number 24315OD,
En el expediente 2435 OD,
you got charged with operating while intoxicated in Sturgis.
le están imputando el delito de que estaba usted manejando borracho en la ciudad de Sturgis.
Then you disappeared for a while.
Y se desapareció por un tiempo.
On that day, you also had no valid operator's license.
Ese día que lo detuvieron, no tenía usted una licencia de manejo tampoco.
Then you got arrested on April 14th for drunk driving.
Y en abril 14 lo vuelven a detener por manejar borracho.
Again, that was in 2024.
Eso fue en el 2024.
Again, driving with no valid operator's license.
Y de nuevo no trae usted una licencia de manejo ese día.
Then in 2025,
En el 2025,
on August 3rd of 2025,
agosto 3 del 2025,
you got charged again with operating without a valid license.
lo volvieron a detener y no trae una licencia válida de manejo.
Operating while intoxicated is a misdemeanor in Michigan.
Manejar bajo la influencia del alcohol es un delito menor aquí en Michigan.
It is punishable by up to 93 days in jail and a fine of up to $500.
Se puede castigar hasta con 93 días de cárcel máximo y hasta $500 máximo de multa.
It carries a fine of up to $500
Le pueden dar una multa de hasta $500.
and it requires that your driver's license be suspended.
Si tuviera usted licencia, le suspenderían la licencia de manejo.
Right now, the plea offer is that you plead guilty to operating while intoxicated
La oferta que le está haciendo el fiscal es de que se declare usted culpable de manejar bajo la influencia del alcohol.
on the February 18th, 2024 case.
En el caso de febrero 18 del 2024,
The city would dismiss the charge of operating without a valid license.
y la ciudad le retira el cargo de que está usted manejando sin una licencia de manejo.
The operating while intoxicated file number is 24315OD.
El expediente en donde se registra que está usted manejando borracho es el 24315OD.
And that you plead guilty to operating while intoxicated in the April 14th case.
Usted se declaró culpable de manejar bajo la influencia de alcohol el 14 de abril.
24630.
Ese expediente es el 24630
OD.
OD.
And again, the city would dismiss the charge of operating without a valid license.
Y de nuevo, la ciudad le retira el cargo de que estaba usted manejando sin una licencia de manejo.
The county prosecutor, Ms. Stoll,
El fiscal del condado, la señorita Stowe,
would also dismiss the no operators license charge from August 3rd of 2025.
le retira el cargo de que estaba usted manejando sin una licencia de manejo el abril 3 del 2025.
If you plead guilty to these charges, I won't sentence you today.
Si se declara usted culpable de estos cargos, no lo voy a castigar hoy, no lo voy a condenar hoy.
I will set the matter for sentencing in a few weeks.
Voy a programar el castigo en unas semanas, la condena.
With the help of an interpreter,
Con la
we
ayuda-
can then do the sentence after we get more information.
Porque voy a aplicar el castigo después de que investiguemos un poco más.
Mr. Bush, what's your client going to do here this morning?
I just want to follow up on the plea agreement, Your Honor.
Yes.
I think it's also implied that there would not be amended super drunk charges as a result of this.
All right.
And he is going to enter a plea to the 2 OWI charges with Mr. George's office.
Okay.
El juez le pregunta al abogado qué es lo que van a hacer hoy. El abogado está pidiendo que te retiren el cargo de que estabas manejando súper borracho y te vas a declarar culpable de los 2 cargos de manejar borracho.
The prosecutor has also agreed not to charge you with the more serious charges of operating with a high blood alcohol level.
El fiscal está de acuerdo en no imputarte cargos más fuertes por manejar con un alto contenido de alcohol en la sangre. O sea, manejando muy borracho, dice.
John, do we have an advice of rights?
Están pidiendo si tienes tus derechos constitucionales. Tienen una hoja.
Mr. Jimenez Gonzalez, if you plead to these charges, you'll be giving up your right to have a trial. Understand that there will not be a trial.
Señor González, ¿entiende usted de que si se declara culpable, está usted cediendo a tener el derecho a un juicio?
If you had a trial, you would have the right to be represented by a lawyer.
Si tuviera un juicio, usted tiene el derecho a ser representado por un abogado.
Mr. Bush has been appointed to represent you.
El señor Bush es el abogado que te está representando hoy.
You could also hire a lawyer of your own choosing if you wished.
También puedes contratar un abogado si así lo quieres o quieres ir con el abogado del tribunal.
You'd have a right to a trial in each case.
Tienes el derecho a un juicio en cada uno de los casos.
If you had a trial, you would have a right to take the witness stand and testify in your own behalf.
Si tuvieras un juicio, tienes el derecho de testificar a tu favor.
You would have a right to have any of the witnesses, either on your behalf or against you, subpoenaed to come to court so they could be questioned under oath.
Si tuvieras un juicio, tienes derecho de traer testigos que testifiquen a tu favor y tienes el derecho a pedirle al juez que ordene que se presenten en tu juicio.
And you have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt.
Si tuvieras un juicio, tienes el derecho a declararte no culpable más allá de...
I have that advice of rights. You understand?
¿Entendió, señor?
Also, it states on here, I understand that if I'm not a citizen of the United States, a plea or conviction could carry a serious immigration consequences, including mandatory detention and deportation. Do you understand?
También si te declaras culpable de estos cargos y te encuentran culpable, podría haber consecuencias con el servicio de inmigración de que te detuvieran y te deportaran, que si entiendes esto.
Do you understand?
¿Entendiste?
This could have immigration consequences if you don't have lawful residency status.
Esto podría tener consecuencias si no tienes un estado legal, si no tienes documentos para estar en el país.
Do you understand?
Tienes que contestar sí o no. Te está preguntando que si entiendes. Yes.
Sí, yo me entiendo.
Yes, I understand.
All right.
Yeah, that has been discussed.
Okay, I just want to put it on the record. We didn't have a signed copy of that. All right, well, let's talk about these. If you want to get deported, this is a good way to try to do it.
Si quieres ser deportado, esta es la mejor manera de lograrlo.
All right, let's talk about the first drunk driving arrest in February.
Vamos a hablar del primer caso de que estás manejando borracho en febrero.
And number three, for assault, family assault. And then that's never a good thing. Number next is that there were 5 counts now of violations. Now there's 8. You got picked up 3 more. It states failing to work faithfully at suitable employment. We can, that's one that we could take up later if necessary. But providing a urine sample in December that showed cocaine in your system, that's impermissible. And number 3, failing to attend batterers intervention prevention program. You're charged with assault, family violence, and that's the heart of the issue. And if you don't do that, you're not fixing the problem. But anyway, you gotta fix that.
Sorry.
We'll get to call somebody.
No, it's no, I received a return on today. Messed up.
Okay. Are we ready? Is that gonna happen again, or is Mike Laird's falsetto voice gonna come out again? Like that? Anyway, you're looking at 10 years and up to 10 years in prison. And this isn't the first set of wrongdoing. We had 5 grounds committing an offense of criminal mischief.
Usually we just come back.
Being in another county without permission, failing to enter and successfully complete the batterer's intervention in the first place, in the first 5. And then now it's repeated. Anyway, what are you going to do? I can make them. No, it's not. We're not deferring to anybody. You can tell me.
We could enter pleas, Your Honor.
Is that what he wants to do?
We could give it up there for signature.
But we gotta number one, you gotta fix. You gotta fix these things, because I can't let you stay out if you're going to admit again to
You're the freaking problem.
No. Failing to attend. I'm sorry. That had to be done. We put you on my God, you put you on probation 4.5 years ago? Is that right? And you haven't done this? Is that right? I mean, okay. Well, that's not excusable. All right. We won't go through this?
Yes, sir.
All right, then 20-34292 is called viewer Floyd Brooks. And this is the state of Texas versus Floyd Brooks. There is a first amended motion to revoke probation that's been filed as of March 2nd, 2026. Does the defendant waive any additional time he may have under law? He has a reasonable amount of time to prepare for this. Can we go and proceed by summary?
He does, wait, no, Your Honor.
All right, raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states that on August 17th, 2021, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation. You were convicted and placed on regular probation for 10 years for the third-degree felony of assault, family violence. And it goes on that this indictment that you pleaded guilty to and were convicted of goes on to state that you had previously been convicted of a family violence assault before you picked up this other part of the allegation in the indictment. So that was the second offense of assault on a family member. And is all of that true that you were convicted that day with a third-degree felony? Correct? Oh, yeah, speak out.
Speak out. Yes, sir.
All right. He had earlier entered pleas of true to allegations 3 and 4, being in another county and failing to enter and successfully complete the battering intervention program. He entered pleas of true to that back in August of last year, over half a year ago. And what the court did was, what I thought was a wise choice, which apparently wasn't, was to continue you on your probation. All of them. Allegation 6 now in this first amended states, I'm gonna pass that one. 7 states you provided a urine sample on or about December 10th, 2025, which showed the presence of cocaine in your system. Is that true or untrue? Yes. True. And 8, you failed to attend. Once again, this is the second notice. You failed to attend the Batterers Intervention Prevention Program, BIPP is what it's referred to as directed by the court, which is inherently important in this crime that you were convicted of. And that was a violation of a special amendment to your probation filed on August 6th of last year, after we went through the first hearing where you admitted not doing it. So did you fail to attend as required the Batterers Intervention Program?
True.
Are you pleading true to allegations 6 and 8 of this first amended motion to revoke probation?
Yes, sir.
7 and 8. You skipped 6.
I'm sorry, 7 and 8. Are you pleading true to those allegations voluntarily and because they are true as they are alleged? That's yes or no?
Yes.
Yes. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation by preponderance of the evidence or greater? Your probation can now be revoked. You can be sentenced to no less than 2, no more than 10 years confinement in prison. Understanding and knowing that, do you insist on pleading true nonetheless?
True.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading truth. Let me see what the percentage report, it would be tough. From probation, if I'd like to hear from you first, if you would be so kind. What happened there that you are aware of? I mean, we called your hand on it in August about attend to how important it was for the BIP program to be followed. Why didn't you?
I do the bill. Then talking about the program I'm in now.
You admitted, no, wait, you submitted that you failed to attend as directed by the court. And what did he fail to do from probation?
So some of the days he felt it's a weekly Zoom meeting and he failed to go weekly. And he was always like the last progress record I got was back in February. So he only attended twice in February. I haven't got the progress report yet. Yes, it's weekly.
I do it every, but it's $25. I have 25 items. Since then, I've been going every week.
Well, since when?
Every week.
But she says you haven't.
Yeah, I've been going every week.
Well, who's
Since-
has he attended or not?
No.
Since
Every week.
I don't know about March, but
No,
February.
no. Since August of last year when we made a big deal.
He got in the because he was in Harris County custody until I think October. Then when he got out, he enrolled in the program. And he
That's
December.
that doesn't
was
do it for
going-
me. You can enroll all day long. You got to go through it and complete the program as directed.
Right. I told you I can do this first week.
He's supposed to do it weekly.
Yes.
Since August, how many weeks has he failed to attend?
It's 15 sessions, but I don't know how many he has actually attended.
Well, how did we file this if we don't know whether he attended or not?
There wasn't a date. I know there's going to be an allegation. And that would-
He actually enrolled in the fifth program in November the 6th, on November the 6th, 2025. And then he didn't get started until December. And
Why?
from December, he
Why?
didn't attend
No,
no
let me
sessions.
start one problem at a time. Why? I thought I ordered that in August
He was in custody in Harris County,
until,
October 8th.
That case ended up.
Is that
getting
right?
Dismissed. That's why we haven't got that case ended up getting dismissed. We don't have a new allegation on that, so.
but back to the BIP, which is what we're here, what you're on probation for is BIP type of problems. The family assaults. It's supposed to be the leader of the family unit, not the record disabler of the family unit.
Dates he attended, judge got missed.
I think for $25 per session.
Failure is not an option. I don't care if you're selling pencils out on the corner, you've got to go to the program. This is it's the essence of the program, of what you're charged with. Go ahead.
I've been going every Tuesday. I don't miss a Tuesday.
It's $25.
$25. I've been paying it since I got a job on. Knock it out. Yeah.
We also, like, I have one report from January
How much time
2026
credited for all this?
where he was attending, but he logged out early and he doesn't get credit if he logs out early with no explanation.
Can I speak?
Hold on, let me read this. Okay.
You had one prior to that was having internet connection issues, so they excused that absence.
Dates attended in December, none. There were at least 4 weeks. And you did not attend any sessions in December. You attended in January 6th, the 20th, 27th. And in February 3rd, February 24th. I mean, we got some gaps here, so.
Just to be forthright with the court, on January or December 30th, he reported he had to work, didn't make it, but there was an excused absence because of connection issues. And there's one that he appeared in December that he logged out early during the session so that he didn't get credit for it. So.
But dates attended in December, none.
Yes, he didn't get credit for anything.
Okay. And in January, 3 out of the 4 weeks. February, 2 out of the 4 weeks. Unexcused absence on 12th. Then 1/13/26, a no-show. And then, let's see, we had connection issues on December 12th, December 16th. On December 23rd, you logged out early with no explanation, no credit was awarded. On February 10th, you said you reported you weren't feeling well. And on February 17th, you were having connection issues. So. So that's
It appears he's reporting it compliant.
That's not what this says.
What if it's probation officer?
Okay, now, so what we've got today is this is the fourth violation he's admitted to. And this, one of these is a crime, cocaine in your system. And then this, a second allegation of not attending the program as required. You pleaded true to that earlier in another motion to revoke probation. So what we do up here is we set a standard. What's good for one is good for everybody. That's fair. We're trying to do fairness. How many violations, intentional violations do you get before it's revoked? And everybody's going to listen because the next person that's going to come up on a motion to revoke is going to go, I'd like the Floyd Brooks rule, please. I'd like to violate 4 times, but stay on probation because you did it to him. Are you going to be fair judge or not? What do I say to that?
Judge.
Oh, yeah, really, the cocaine? Where did you get the cocaine from?
From friend.
Well, who? See, you're not even you aren't going to give up your source.
No.
And that's the way it is.
Thank you.
That's the way it is.
Thank you.
No, that's, of course, you think I don't see this after 45 years in this business?
Oh, well.
Come on. No, I'm not going to beg. You promised that you would follow the rules when we placed you on probation. This is the 3rd time you've been up here. Originally, the first motion and now the second. How many chances do you get? Everybody's going to watch and go, I want the chances. I want to be able to foul up 3 separate times, knowing I made a promise not to do it at the first place. You're running out of chances with me. What do y'all say?
Your Honor, I'll just, if I might be.
How much time?
Require the probation officer to be willing to work with him and what she thinks the future.
I thought they were willing to work with him when we placed him on probation 5 years ago.
Well,
4.5 years ago. It's his problem. Now we've had to deal with it. And this is way too many times for crimes, for drugs, for not taking care of the whole source of the problem, the battering issues. You made bad choices. You don't even attend that regularly.
Your Honor, if I might, I think that the ultimate goal of probation would be to rehabilitate someone and be able to restore them to society in the condition where they're able to participate as a full legal law-abiding citizen productively. And I know that
Wait, what's law-abiding about buying cocaine? Or purchasing drugs, cocaine? It's a second-degree felony.
It's a continuing struggle with Mr. Brooks, but obviously there may be some positive things too that he's made progress with that would militate in favor of at least giving one more opportunity to do this probation. He has indicated that he's employed now. That's a huge part of probation.
Yes.
And he doesn't appear to be
this is his third opportunity. He was placed on probation the first time that we had a motion to revoke probation that I did it again. And then here we are.
Well, it seems to be reporting is required. Your Honor is working. That's probably I would say maybe half of what he needs to do. The other half he's
committed crimes.
I don't have an explanation or excuse.
I know, it was just, you're in a hard spot. We set a standard up here. The victim in this case, do you still,
No,
you have no contact with that person?
I'm not doing that for now.
Sir?
I'm trying to go.
He's asking about contact.
Yeah.
The person who was the victim in the first place, that's, I mean, you're not still married to that person or, okay. Well, sometimes that happens and that's a problem when because I want a family unit and sometimes people make mistakes and we can work with keeping them together if that's in the best interest of everybody and we're sure that a problem's not going to happen. But that's not an issue here. I don't like breaking up families, but these are serious. The family unit was an important part of this of America.
If the court's inclined to ask for something lower and applicable statutory range.
It states.
Since he's not been to prison before, we'd recommend 5 years.
What you hear what we're saying? What do you say? You have a chance to be heard. You have 180 days credit. That's a half a year, but the state's asking for 5 years.
What do you have to say?
It's a crime of violence. I mean, people don't find that amusing.
I need more plans to be out in this world. I can work. I'm gonna try and might get in no more trouble.
You made that.
No more trouble. Real nose. Real pay everything. Please. I'll be real. I'm gonna do my classes on time. I just want to work. What's it?
That's fine. You made a deal with me when we put you on probation. I've received a copy of this order you signed, that you signed. I agree to follow all conditions imposed, and I know this probation can be revoked for any violation. This is the second time since then you've been before me for violations. You broke your promise twice. These are important things. It's not just you committed a crime, but the batter's prevention is important to fix the choice you made here on assaulting a family member. This person, the victim in the first place, was that your wife? What, your wife?
That was my girlfriend.
Okay. That's the wrong way to show affection, for someone you care about. Right. If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 7 and 8 have been proven true, based upon the defendant's voluntary and knowingly made plea of truth to those allegations. Thus, I find this first amended motion to revoke probation to be granted by preponderance of the evidence or greater. Your probation is hereby revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years, and you will be given credit for time you have served in this. Do you understand what has happened today, sir? All right, that's all. Amanda Nolan.
Yes, she's in that.
Audwin, on Lisa Carmen, what are we going to do?
We have a reset for a quick reset at the end, April. We'll do this time. I don't think the snow, I don't think she was brought over the office.
Serious?
Well, let's figure it out. Okay.
So now I wouldn't.
Well, let's
Yeah.
find out why.
She's having.
You have something else, don't
She
you?
has medical issues, so I'll be.
On Audwin, okay, in 15-22728, Lisa Harmon,
Yes,
what are we doing today?
setting for the.
Come on up. How do you pronounce your first name? Duracia or
Delicious.
Duracia Williams? And Mr. Kindler is here and the state's attorneys are here. As you know, there's a motion to revoke unadjudicated probation in this cause number 25 CR 425. Does the defendant waive a formal reading of this motion filed on December 12th of 2025? Can we proceed in summary?
Yes, Your Honor.
First thing we're going to do, there was an issue raised by the defense on the defendant's competency as to whether she was or was not competent to proceed with her proceedings. Ordered Dr. Edward Pond, licensed psychiatrist, to evaluate the defendant. He is prepared, and we've received a report dated March 20th, 2026, finding the defendant to be competent. I'm going to call this report Court's Exhibit 1 on this date.
It's here to stay.
And it will be made a part of the record in this proceeding without objection.
Okay.
So I don't think. Okay, it is received. And we can proceed in summary.
Yes, sir.
Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke unadjudicated probation filed in December of last year in this cause number 25 CR 425 states that on July 9th of last year, 2025, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true?
Yes.
One state you committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue? Did you,
I think,
have y'all talked
I think
about
she's previously heard.
no, this is the only motion here, and there's nothing on the face of this. I would light on.
Judge, I wrote on mine that she entered pleas are not true on January 30th.
Okay.
And
I wouldn't put that. Well, I thought, what are we doing? Is she admitting to anything here? And
I think she didn't admit to anything back on January 30th. We conducted a hearing.
Okay, what are we going to do today? Is she going to admit?
She's been found competent. I think the issue of competency was raised prior to that disposition.
Well, there it is.
She's been declared competent, so I mean, we proceed to a disposition at this stage.
Well, that's what we're trying to do. So what are we going to do?
Your Honor, my understanding is that the state presented all of its evidence on January 30th. I had Officer Lonick testify about the proof as to the assault that he occurred to him, as well as the fleeing. And that was where the state limited its evidence on presentation on January 30th.
That was January 30th, right?
January 30th, counts 1 and 2. We have video evidence that showed that the fleeing was, in this lawyer's opinion, obvious. And then there was the body cam footage that showed where she struggled and kicked him in the appropriate areas alleged in the assault. And if necessary, we can retrieve the video that was placed in evidence to remind Your Honor of the evidence. So after I passed the witness and Mr. Kimler was cross-examining the defendant, he was raising the issues about her mental stability. And out of caution, Your Honor, ordered the examination. She's been determined to be competent. I would ask that the court.
Let's pick up where we left off in that hearing.
I would ask that the court make findings of true as to counts 1 and 2 and proceed to punishment.
Well, what do you have to say?
Disposition. I think that's accurate, Your Honor. And then if my refreshes my recollection about what occurred, I think while the report, if I could slip over an ordinance, while the court does find it to be competent, there are some indications of mental health issues that may militate in favor of more lenient treatment with the disposition of the MTRP.
Okay, then the court will find that based upon the earlier hearing and this hearing and presentation of evidence concerning the defendant's competency, where the defendant is declared competent, that the defendant pleaded true to, she didn't plead true, that the court found, based upon the evidence presented, true to allegations 1 and 2 by a preponderance of the evidence or greater, that the defendant committed the offensive assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her probation order, and that she committed the offense of fleeing a police officer on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her declared unadjudicated order. The court not only deems it meets the threshold for preponderance of the evidence, but the court found it true beyond a reasonable doubt in each of these cases. So what shall we do? Defense?
Well, Your Honor, many times, thank you. I think when people are faced, which some people are faced with an action with law enforcement, they react in a way that doesn't seems to defy explanation. I would observe that Ms. Williams is on probation for a previous offense of dating, which of course involves the action of law enforcement. Now, this interacting with law enforcement in a way that has resulted in this MTRP being filed. I don't know that the competency exam goes into her mental health history rather extensively. She's in a position to kind of maybe indicate to the court why she seems to be triggered by interaction with law enforcement. I would observe too during the incident now that's given rise to the allegations of the MTRP, there was no contraband found in it, or there really seemed to be no rational explanation for her actions, other than just she has, I don't know, I'm not an expert, but PTSD and a triggering event dealing with law enforcement. I'm not trying to excuse it, just maybe trying to contextualize it, that she could maybe tell the court what was going on in your mind, the heads interactions with the officer.
No, I blacked out.
She's mumbling. I can't hear you.
I blacked out. I really don't even remember. I'm scared of the police. I'm scared of the police.
Is that the root of your troubles, you think?
I believe it is.
Nobody knows more about you than you. Let me ask you, have you ever been convicted of any other criminal offenses?
Yes.
Yes.
Okay. How many times?
I don't know.
You don't know how many times you've been convicted of a crime?
Twice.
Okay. Is that your
violence? Yeah. Twice.
Is it?
Yeah.
No, I'm talking about for any misdemeanors or felonies that are above a Class C misdemeanor, above a traffic offense. Crimes.
Probably 5 times.
Sir, ma'am? 5? 6. 6 times.
It's closer.
Well, we're not playing horseshoes. This is real life. You should know better. You should know more about you than, well, I shouldn't have to correct you on that one. This should But that's 2, 2, 4, 6, 8, actually 9 times. 9 times. 9 convictions. But what does that say? You know, that's from 2011 through 2024, and now this one. You're looking at on a probation. I mean, I stuck my neck out on this one with this criminal history, and it's assault, prohibited weapon, switchblade, and brass knuckle or something. Assault, family violence, resisting arrest, failure to identify, driving while intoxicated, resisting arrest and search. Those are all, they're misdemeanors, but they're still, you were arrested and then you had to serve jail time. You, every one of those were, one was 2 days, one was 9 days, and the rest were 60 days or more. Anyway, that, and you know, evading arrest has consequences because this is, let's see. You had 3 resisting arrest convictions before this one. So, you know, evading or resisting are in the same family. They have consequences. All right. He has 83 days credit here. This is a 3rd-degree felony. So what should we do?
Judge, my suggestion is a 5-year sentence. I think it's warranted by the criminal conduct prior to her being placed on probation. It's additionally warranted because of the offense, it was the felony offense that was committed that Your Honor saw the video on. And frankly, I still remember this officer testifying now 2 months ago. He showed great amount of discretion with this individual. He could have charged her with the same offense. She was on probation and chose the misdemeanor offense of fleeing instead. I believe Your Honor even commented on the record about that, just the length of time that went with here and then the number of officers that it took to get her just to comply speaks volumes.
Right.
Then if we go past that, and this year she's had 10 different violations that she's been written up for in the jail that she just doesn't want to follow rules. I don't believe putting her back on probation is going to be beneficial for anybody. Certainly not for Jefferson County. I think the 5 years would be appropriate.
Defense.
Your Honor, I don't disagree with Mr. Ham's characterization of the officer's conduct in this case. I think he showed remarkable discretion both in interacting with the defendant and his choice of charges to file. So certainly I don't take any issue with the officer in this case. He went above and beyond to try to treat Ms. Withers appropriately.
What are you suggesting we do?
Well, without hearing from the probation officer, I don't know if they're willing to continue to supervise her. If there's still a chance that maybe with some sort of mental health intervention, you may be able to mediate the issues that she seems to have occurring with law enforcement. That would be one thing. If the court is inclined to revoke her, I'll ask the court to consider taking into consideration mental health issues and consider lower end of the statutory range.
Anything for probation?
No, sir, we just didn't have a chance to really spend any time with her. I mean, she got on probation in July. She got a new charges in October, but during that time, she never told us anything about any mental health issues.
Yes,
So we'll address that.
Yes, sir. Anything you want to add, ma'am?
I mean, I asked my probation officer, but I was in Houston, so I don't know who I should have talked to. The one in Houston or the one, I mean, it was kind of confused.
She may have been reporting in person.
Well, the important thing, the first thing you have to do is not commit another crime, which you did twice, along with the other 9 prior convictions. Court finds that these are new. What are you going to do with those?
She probably has sufficient time served on these.
Which one's Judge?
a misdemeanor.
Yes, the October 19th.
All right, so I have a felony offense that's pending for the assault on peace officer. And in misdemeanor court, we have the fleeing offense.
Is that where it is?
Yes, sir.
Right, I will find that if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation and grant it by preponderance of the evidence or greater, as the court finds allegations 1 and 2 proven true, as the defendant is admitted these violations, and the court earlier in the hearing found them to be proven true not only by preponderance of the evidence, but beyond a reasonable doubt, that assault on a public servant and fleeing a public officer criminal violations were committed by the defendant on her probation. Thus, that is a violation of her probation order. Her probation is hereby revoked. Earlier in this case, the defendant had pleaded guilty to the third-degree felony of evading arrest or detention with a motor vehicle voluntarily, knowingly, intelligently. There was sufficient evidence supporting her guilty pleas from State's Exhibit 1. Her guilty plea from State's Exhibit 1 admitted her plea to support her guilty plea to find her guilty beyond a reasonable doubt. I had deferred any finding of guilt at this time. The court is moving forward based on her violations of probation. I now find you guilty beyond a reasonable doubt of that third-degree felony you had pleaded guilty to back in July of last year. And I find you guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all the time you have served in accordance with this case. Please do that. All of those things. Okay. Anything else? That is all.
We may be in another sense of that.
On who?
On Miss Williams of assault. I'm going to talk to her about that.
And what are we doing on Amanda?
She's not here.
I'm gonna call the jail. I feel like she made it 3 minutes this morning.
Okay. So on Amanda Nolan, we're going to pass on that.
Yes.
Okay. See what you can do on that other.
We'll have
Langston.
We'll have to.
Yes, sir.
Yeah. We only wrote.
Mhm. Yeah, the
1 and 2. And then they're gonna work out the sentences.
right. Well, that's what it sounds like.
Yeah.
This is who is
It's not a indicted case, it's the one you.
Oh, this is the one you set the bond on.
Bond thing,
Oh.
is there's.
I know about this one.
Yeah,
yes, okay.
you just wanted to go over it like today.
All right. There's a matter that was presented to the court yesterday by the Criminal District Attorney's Office for Jefferson County, Texas. And you are Charles Wilson III?
Yes, sir.
And you were here with Mr. Adams, your attorney, and the state's attorney. The state of Texas filed a notice for a review of a bail decision. You had been placed on $65,000 bond for an aggravated assault and a $15,000 bond for family violence. And the state of Texas, the district attorney's office deems that amount is insufficient under the law to ensure that you will properly appear and answer before the court and to ensure the safety of the community and the safety of the victim. And for those reasons,
Court is Mr. Lewis, right?
Yes, Your Honor.
Represented by Mr. Newberger. We have Mr. Harrison, the prosecutor's office, and Officer Nelson from probation here today for a final violation hearing. Mr. Newberger, does your client wish to have a contested hearing in this matter?
He admits, Your Honor.
Mr. Lewis, do you understand the rights you're giving up by admitting to this violation?
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
Do you admit or do you deny that you violated the terms of ILC?
I admit, Your Honor.
Based upon your admission, I find you have violated the terms of community control. Mr. Harris, on behalf of the state.
Your Honor, Mr. Lewis has been non-compliant in several ways, including not following through with treatment. He provided a positive urine screen. He also cut his monitor, which we are requesting restitution to Warren County Community Corrections. That was in the amount of $190. As far as his ILC is concerned, I think through his actions, he's shown that he's not able or willing to follow through with that program. We would recommend he be revoked from ILC, and that if he is put on general book probation, that he complete a lockdown CBCF treatment.
Officer Nelson?
Nothing further, Your Honor.
Mr. Newberger?
Just to affirm what I said in chambers, Mr. Lewis has expressed to me, independently of meeting with anybody else, that he can't do this on his own. And I agree with what Mr. Harris said, to the extent that he is not able to succeed without going to a more controlled environment, a CBCF. That said, I'd like the court to, he'd like the court to consider giving him one more chance at ILC, but in a most restrictive facility where he could get the treatment that he's unable to manage on his own.
Anything you want to tell me, Mr. Lewis?
Your Honor, that right there is what I admitted to him earlier when he came to talk to me, is that I would like to go to CBF so I could actually have a better environment to complete this in.
So here's what I'm going to do, Mr. Lewis. I am going to modify the terms of your intervention in lieu of conviction to order that you enter into and successfully complete a community-based corrections facility, and you're going to be on 60 days of electronically monitored supervision with a curfew upon your release. Officer Nelson, I know that the community corrections people are going to be very angry about that, because I'm not supposed to put somebody on EM after they cut, but I'm going to do it anyway. And I'm going to set restitution in the amount of $190. I'm going to set this for another violation hearing, a final violation hearing, 60 days after you're released from the CBCF. At that point is when I'm going to make a decision whether or not I'm going to continue you on ILC or revoke your ILC. So if you do well at the community-based corrections facility, you get out and you start cooperating with Officer Nelson, and we see what Mr. Lewis looks like at 100% engagement. Maybe I'll let you keep your ILC. If we continue bumping along at the bottom of the barrel, you keep testing positive for THC, all that stuff, might as well just revoke your ILC and get you onto the general book probation. So we'll get it set 60 days after he gets out. Anything else?
Is there a finding then today on the that he has violated? Is that correct?
There is a finding that he has violated, and I'm continuing it for another final hearing during that time period. So we'll see. You still got a chance. What's that?
I'm sorry, Judge. So there is no final disposition today.
Correct.
It's continued for resentencing following the 60-day period following his release from CBC.
It wouldn't be sentencing. It would be set for another final hearing on the ILC violation.
Okay.
But there is a finding that he's violated today.
Yes, he has violated his ILC. We have not yet made a determination as to whether I'm not going to revoke his ILC.
Okay.
Okay.
And he does have 65 days of jail time credit.
All right.
Thank you.
All right. I'm going to remand you to the custody of the county sheriff pending transport to the CBCF. Hopefully that'll be soon.
Thank you.
Thank you.
Thank you.
Do not. You pay for second service.
They ask for a review of this bond decision, and the court has 24 hours to make a decision. And so the court made a decision yesterday because of some them emergency matters that prevented all of us from getting together, but I had to make a decision. And this court did make a decision finding this finding this request in good cause, for good cause. And upon reviewing the public safety report, the probable cause affidavit, and the other documentation in this file on these cases, the court raised your bonds to $100,000 in each cases, and also ordered that if you post these bonds, you must remain at home. You would be on home confinement, except for allowing to leave home only for necessities of food, medical care, and meeting with your attorney. And you must travel to and from your house in the most direct route possible. You must have a GPS device if you post these bonds, so that we know where you are at all time, and to ensure that you're not violating these conditions. And also, let's see. I think those are the essential features of what the court did. Now, because the rule of law states I have to make a decision, and we couldn't get together, I asked you and your attorney in the state to have a hearing today to show cause why, and present any evidence why the court's decision should not be continued and enforced based upon what the court deemed yesterday. And I'm giving the defense an opportunity to be heard and to present any additional evidence you want me to consider. And so I will consider modifying the bond decision if I find good cause from evidence presented. Go ahead.
Yes, Your Honor. Specifically, Judge, under 17.028, it's the state burden to show that the safety of the community and ensures that the safety of the victim of alleged offense warrants this increase or request to review his bond. Your Honor, we ask that the state disclose you what we would believe to be Brady information as it relates to the state's burden as to safety of the community or the safety of the victims. It's my understanding, and I'll ask that the state to disclose, if this is true, that the alleged complainant did not want the bond to be increased, one, and that two, in fact, this Tuesday, she went to the district attorney's office to have the charges dropped. If that
by Mr. Aldridge, we have Mr. Harris in the prosecutor's office, and the victim is also present today. We are here today for a status conference. Mr. Harris, what's our status?
Your Honor, my understanding is there was really some pretrial discussions in this matter. My understanding was that there really was no offer as far as anything with the charges. The defendant was to plead guilty. There were some discussions about sentencing. However, we have not reached an agreement. My understanding is defense wants to set this for a jury trial at this time. We are prepared to go forward with that.
All right. Mr. Aldridge, we have a motion pending to modify the bond issue.
That's correct.
First of all, I'm sorry, Officer, what's your last name? Williams. All right, Officer Williams. We're here today both for two things, status conference and also on the request to modify Mr. Reynolds' bond. He was granted an OR bond. That's an agreement that he's going to get out. I don't want to talk to you like you're stupid, but not everybody knows that. There was a requirement that he be supervised on electronically monitored. He hasn't been able to provide a verified address, so he's still in jail. And Mr. Aldridge is requesting that I remove that requirement. Do you have a position on that? Okay. Mr. Aldridge, we had some discussions about an arrangement whereby perhaps Mr. Reynolds would enter a plea of guilty to this charge and do some time in the local jail, that he is not interested in that, and that we are setting this for trial, right?
That's correct. I have gone over that proposal with my client, and he not in agreement, correct?
So like we just discussed yesterday, if you pled guilty as charged, the judge would order pre-sentence investigation report, hold you here in the local jail. Okay, and then upon sentencing, release you and terminate the case. That's what's on the table. If you're not in agreement with that, we're going to set it for a jury trial and then proceed on both felony charges with obviously the risk of prison time if you get convicted. Correct. Do you want to do that?
Can I have a few minutes with my client, Your Honor? Seems like there may be some changes.
Okay, yeah, that's fine.
Thank you.
That is true, and that would be Brady. That would clearly be Brady for purposes of a bond hearing. If she in fact went to the DA's office to have the charges dropped, and if in fact she did not seek to have this bond increased, then on the legal issue of 17.028, safety of the victim, that's clearly Brady, and that would go to that particular, that's my position. My position would be that would be Brady, and I would ask the state to disclose whether in fact.
And how does your client know that she went and did that? I didn't tell anybody because I don't know about that. How did he know? Has he been in contact with the victim, which he's not supposed to be doing?
Well, let's say this. If in fact that is true.
Yeah.
Again, my position.
If y'all want to conduct a hearing on your own, that's fine. But
I think that that's Brady. That's
so the court's decision. The court's decision. Even though the state of Texas always has the burden of proof in these matters because of the presumption of innocence standard, this court still has its own independent access to the probable cause affidavit and the criminal history, which I am required by law to review in determining bond issues. That's why I made my decision and found that the bond was too low and not appropriate under the circumstances this court reviewed. I'm giving the defense an opportunity to present any evidence you want.
And I have evidence
too that the court will consider in whether it will modify my bond order from yesterday. Go ahead.
Well, Judge, Mr. Laird says that he's unaware of that, but if in fact that is true, our position is that that's Brady, and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady in our position.
The experience has been this office has been very sensitive about Brady. We all should be. We all are, and I've not found them to intentionally.
No, I'm not saying he's not
Brady material. They honor their oath and conduct it responsibly, just as you do in your.
Yes, sir.
Go ahead.
Judge, I would just ask that, I understand he can't do it now, but at some particular point in time, since he does not know, that he look into whether or not the lady came up with the drop charges, and he look into whether or not she did not pursue this. But I got evidence other than that. But that's why I got other evidence.
Okay, that's the court. We'll note that, and it's in the record. But at the end of the day, the decision is in the executive branch of government, not her.
Right.
Somehow, some way, she was a complainant somewhere along the line. And when that happens, then the executive branch of government takes over and does what it does under their responsibilities of the oath that they have taken under the Constitution and the laws of the state of Texas and the United States. So I don't find that they've done anything inappropriate in this case, except follow their oath. And We've had situations where complainants change their mind for whatever reason. The worst thing that can happen though is if they decide to change their statements of victimization based upon influence or coercion or even contact on behalf of the defendant, it would be catastrophic for you. Because this court takes no prisoners when that is found to be done. You cannot disrupt what this Constitution stands for and what the laws stand for. And that's what happens sometimes when people behind the scenes try to influence others who are involved in the criminal process improperly. That if that is done, it will be dealt with severe. But nonetheless, I don't have any reason, I don't have any information before me to change what the court's decision was yet. And that's why I'm giving y'all a chance.
And I'm gonna call my client as a witness.
Charles Wilson III?
Yes.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right.
Yeah, speak out.
Yes, sir.
Okay.
All right.
Your hand. Thank you. Go
All
ahead.
right, Mr. Wilson, you understand that I'm not going to ask you any questions at all about the facts for this particular offense. I'm asking you nothing but offense. You understand that? Yes, sir. And you understand on our rules of evidence that you testifying on a preliminary matter does not subject to the cross-examination for any other issues. The only question that I'm asking you on about is for financial abilities, right?
And before you get through, I don't think that's accurate. I think I can cross-examine him on any issue because part of the rules or part of the reason the judge made his decision was on the safety of the community. So I can talk to him about the offense. So before you put him up there, you better get a ruling.
Judge, I don't think that he's subject to cross-examination. All I'm asking him questions is about his basic income and his ability to afford a $65,000 bond. And asking him about his income has nothing to do with whether or not he committed family violence against this lady. And
I think it does. The issues on bond are the ability to follow the bond conditions and whether his release would be a safety to the community or the victim or others. They can go into this because part of the bond conditions is not to commit first thing, don't commit another offense. But it opens you could possibly open the door for this subject matter to be allowed. Yeah, I'll get a break.
No,
right now. Stand by. I'll be right back. Thank you. What are we doing with the final?
She's coming.
Harmon? Yeah. Is he coming back?
Might real quick, I could be not, I'm doing super fast. Unless they are gone.
This is a motion to open up probation.
It's all good, okay? Okay, you know, okay.
I picked that up.
Yeah.
Zion Harmon,
If they can.
24 CR 83 is called. And there's a motion to revoke unadjudicated probation here. You will hear with Mr. West, your attorney and the state's attorney. What do we, you had pleaded true earlier in March, on March 20th. So that's just the other day. Failing to report and turn himself in. for state intermediate sanction facility as directed. Anyway, what are we doing?
Your Honor, since then, I believe he has done everything he's supposed to do, but I'll defer to the state on that.
Judge, it's my understanding that it was held in abeyance and he was ordered to go to ISF, and I could defer to probation, but she does say that he has been successful since in completing ISF and since completing ISF.
Yeah.
So what do we do?
If you want to go ahead and dismiss it, because he has been doing well, then we can.
He's on probation though, right now for 10 years.
Not the
From 24?
Yes, sir.
Okay, so this motion to revoke unadjudicated probation is,
Dismiss.
y'all send me something out?
Yeah.
Yes,
And then keep him on probation.
That's all. On April Francis. Who's here on that from probation? April Francis. It's a review, probation review. Nobody? Nobody at all?
You know, she was here just a minute ago, Your Honor.
He was here a minute ago.
She's presumably still on.
Well, who is it?
So,
Yeah.
this one.
Okay, when they get here, let me know.
No, I'll-
Then I've got Calvin Walker to deal with, but I'm gonna get this other DeMarcus Maya.
That's Judge.
What are we?
He's the one.
DeMarcus Meyer, what are you doing?
Judge, we're going to ask that he be released back onto probation.
Uh-oh. Okay, who's here on that?
That's
the mistake.
You released what?
Back to probation.
Wait, no, I think it was me.
Not without a plan.
Mr. Valerius.
I got plans. Let him back at probation.
You come home with you?
Sure.
And stay there?
I don't have any. I might even let him use.
Come on up. 234765 is called DeMarcus Meyer. That's you? Is that you, sir?
Right.
Okay, you were here with your attorney, Mr. Turk, and the state's attorney. What are we doing today? There's a first amended motion to revoke unadjudicated probation.
Yes, Judge, my understanding, well, yeah, original one was filed back in.
What are we going to do today?
Asking that he be released back to his probation status.
What we're going to do is know, was he admitting to this or not?
No, Judge.
Then we're having a hearing.
Well, Judge,
We're not going to do anything before we have a hearing.
Yeah, well, except for hearing,
We have a hearing.
yeah, the main thing is he's not following his Spindletop plan, and before he's ever released on anything, we need to make sure that he understands to take his medications. If when we get there, when we do the hearing, we'll determine what we're going
Is
to.
this boring you, sir?
No, sir. It's
he's
it's
frustrated.
just, I'm not frustrated at all. I'm prepared for anything that's not coming my way. I'm living by my faith.
Uh-huh. Well, the important thing is you also live by the law as well.
I did. I didn't break any of these laws.
All
They said
right.
here.
You're presumed innocent. Okay. Well, all right. What are we going to do today?
Except for hearing, Judge.
Judge, I'm gonna have to get his medical records from Spindletop. So
Okay, we're not going to do it right now.
No, sir.
Y'all aren't ready for a hearing.
No, sir, I need to get.
When
the-
can you be? Because
It's
it's just
been
sitting
a
in
long time to
jail
get
and
the
we don't
medical
want.
records, and we're gonna ask for a bond considering he's been largely compliant with his probation.
When can you be ready for a hearing?
I don't have them, as soon as they can give me medical records, Judge, I can't make.
Here's the problem. Is that the bond's going to be high because he's alleged to not participate. He's not actively participating in treatment at Spindletop, which is a key thing to everything. These are allegations 5 and 6.
Yes, sir. My understanding is the reason that the state filed this is because he was a purpose of interest in a case that has been.
Failed to actively participate in treatment. That allegation is that he didn't go to the treatment.
Did he miss one appointment?
It says on February 4th and February 19th.
Yes.
That's 2 appointments, isn't it?
I believe he the next day, Judge, and. I
I'm
believe
sorry.
they-
It's
they-
those appointments are important. They're necessary.
I was there today.
Judge, he's been there every day. It's 2 times.
Oh, y'all ready?
Not taking his medication.
Okay, Judge.
I've been taking it at the jailhouse.
Okay, there's an issue, a fact issue. When can you be ready on this? What are we doing next week?
Docket.
Okay.
Needs medical records.
I gotta get medical.
How long would it take you to get those? But they were right there, aren't they? At the,
Yes, they are, Judge, but I can't, I mean, I can ask the state to subpoena them to maybe make it faster, but I don't dictate when they give me the
what,
records.
how much time are you asking for?
4 months. It's gonna have to be in late May.
For a hearing?
I leave in 2 weeks. And I will be gone for April.
All right. Okay.
If I can get a faster, I'll let the court know, but I don't know when there was a vicinity. I'm asking that he be able to go back out on probation status and that's.
All right.
He's been largely compliant. He's been in court. He's compliant.
These allegations are very disturbing. The treatment is, and
I don't know
first
what
of all, it's
happened.
an assault by,
That was
an
abandoned.
assault. I'm sorry, what?
My understanding is the first and fifth allegations were abandoned. The second and third, possibly the fourth, are the ones that held in
Failing
abeyance
to report,
from 2024.
failed to report, failed to immediately report to probation office's source of income.
And he was since
Failing to participate in
a
the
rehab
treatment
center
of
for
Spindletop. Okay, and on the state, who's on this one?
Right.
Mr. Laird, on this, he's saying that there are 2 of these allegations are to be abandoned. Is that right?
The first and fifth, according to the notes I have and what's been given to me, were abandoned.
That was in the previous hearing that we had, because we've had
Is
one
that
where he's
what we're
pled
gonna do?
before, yes.
So 1 and 5 are to be abandoned?
It's not gonna be jeopardy for the same time.
That's what, there were some notes on, one of the previous hearings that you had where that was true, Judge. No, Mr. Turk showed me those notes earlier.
It's, okay.
So
I have on the original motion, a plea of true to 2 and 3.
right, so 1 and 4 would
And
have been the one, because 5 is the first amended.
Then the first amended rolls around on March 4th.
1 and 4, so
Yes.
5 and 6 are the ones that
5
were
or 6 are this last
were
month.
up on this time, Judge.
And 2 times that he's missed out of the weekly attendance.
They're saying that one of those, 5 and 6, one of those doesn't have a basis that he.
Sorry, I
He
may have
didn't-
misquoted the clean understood. It was the first and fourth.
Should have been 1 and 4, because 5 and 6 we just filed, so we couldn't have abandoned those back in the last hearing.
Okay.
That's my mistake, Judge.
Okay.
My mistake.
So he failed to participate in treatment to Spindletop on February 4th and February 19th.
Correct, Judge.
How often does he go? Twice?
Follow-ups are supposed to be every 3 months.
Ma'am?
Every 3 months.
I think he goes a day.
What's this? He failed to go on February 4th and then
And
2
then
weeks later.
the 4th was an appointment, and then they rescheduled it to the 19th, and he missed that 19th.
Okay. Okay. Why'd you do that?
I didn't miss it purposely. I was
Well, I know what happened.
Ubering.
Sir?
I was Ubering and got a Uber.
He wasn't able to make it.
Oh, Uber? What time do you have to be there
Oh,
generally?
is he asking me? Yes.
He's asking me.
That day, I thought it was like, I think maybe 2.
Okay, hold on. Where we,
But the problem is not just dismissing judges. I don't believe he's taking his medications is the main problem. And that's
Well,
where he starts getting
nobody's
into.
alleged that.
Well, that's part of the treatment plan. It says not following through the Spindletop. Active participate in treatment through
But
Spindletop.
he missed, according to everybody, he's just missed once, right?
Essentially, yes. What so it was just described.
Well, essentially, it's yes or no, once, right?
He was late apparently, but I think he went back to try to do it the next day.
But it's essential that when he misses those, we know that he's not taking what he's supposed to be doing.
Okay.
Well, part of the reason I want to get to.
But it says fail to actively participate in the treatment. If it's one time, I mean, if, how long has he been doing this?
He was placed with me back on April the 8th of 2025.
A year?
Yes.
Okay, how many treatments has he missed?
That,
Just this one?
yes, because their Spindletop system did go down because they were hacked. So at one point, they were just trying to get everybody, they kept pushing everybody's appointments back.
Okay. Oh,
So
okay.
And I don't know what actively participates means. He's also been told by his provider some things too, but I'm trying to
Okay.
verify.
y'all still want to move forward on the motion?
Yes, sir.
Okay, that's okay. I'm gonna grant him some relief on a bond.
Yes, sir.
But I'm gonna let you, I'm gonna release you. Can you pay attention to me, please, sir? You know what it feels like when you don't seem to be interested?
I'm just
And I'm doing my speaking here because I'm gonna make orders of the court that you have to follow, that you're gonna be held in custody if you don't. And I just want to make sure that later on you go, I didn't hear you because I wasn't paying attention. Okay. I'm gonna release you on a personal cognizance bond. You have to follow all terms and conditions of probation, which includes this actively participating in the treatment through Spindletop as required. All right, I'm going to reset this hearing though in 4 weeks. Okay, 4 weeks.
I'll do it when Brett's back.
Okay. Yeah, and we'll see where we are on all of this. But once again, a failure on probation, your probation can be revoked. You could be found guilty and sentenced up to 10 years in prison. You don't want that, right? I wouldn't. All right, are you going to follow all the rules?
Yes, ma'am.
Thank you. So, that was the Marcus Meyer, right? He has 2 cases against all. All right, where are we? We're here.
Practice, no one's good.
Here's Meyer. Amanda Nolan. And then I've got,
Meyer.
I'll give it to you. I've got Dorisha Williams and April Francis. Come on up. Yeah, let me do it. No.
That's cool. Okay.
And who is it? Come on up, man.
Dorisha Williams, he is on the tag.
Thank you. Dorisha, come on up. 25 CR 183A, this is called. Thus, the defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary? In summary, this indictment alleges that on or about October 19th, 2025 in Jefferson County, Texas, you committed the 2nd-degree felony of assault on a peace officer or a judge. Do you understand what you're charged with? Yes. This is a 2nd-degree felony, which carries with it, if convicted, a term of not more than 20 years or less than 2 years in prison. In addition, fine may be assessed not to exceed $10,000. Do you understand? Do you understand?
Yes.
An agreement's been reached. You would be pleading guilty. Sentenced to 4 years in prison to run concurrently with other cases. Is that your understanding?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this? How do you plead to this, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Show you what's marked Exhibit 1 here. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Is everything true and correct? States Exhibit 1 hindered, without objection admitted. The state you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. If you were guilty of the crime charged and any lesser included offenses and you are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct?
Yes.
States Exhibit 1 presented and it is admitted into evidence without objection. Pre-sentence report is away. I will follow this agreement. I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this offense. I now find you guilty of the 2nd-degree felony of assault on a peace officer. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. In this case, you will be given credit for all time you have served in accordance with this case. Do you understand what has happened today? Yes. That is all. Thank you. I have a dismissal on Patrick Pittman. In 26 CR 307, Mr. Hammond presented this on this date. It is signed and granted. Yes, Langston, what are we? Yeah, we're ready. Come on, what are we doing?
I think we're gonna just, I look back at Rule 104, and if, as long as he sticks to financial, I cannot cross-examine him on the offense unless he talks about the offense or brings
Okay,
it.
so what are we gonna do?
I'm just gonna ask a quick financial question, and we can let you make the decision, whatever it's gonna be. It'll be super fast.
And this is. Huh?
This is the state of Texas has requested a review of.
Yes, all right.
All right. Did you hear what I'm not gonna ask you anything about the facts of the case. Don't tell me nothing about the facts of the case, right? You got me? The only thing I'm asking you is a money question. That's it. Got to do with money. Don't let me say nothing about the case. You got me?
Yes, sir.
All right. So you understand that Judge DeLuan, who initially set this bond, I think he said a $65,000 bond and a $15,000 bond, right?
Yes, sir.
All right. So if you go to a bail bonds when they charge you 10%, that'd be $6,500 and then $1,500. It would be a total of $8,000, right?
Yes, sir.
Okay. Right now, do you have $8,000 in any bank account anywhere?
No, sir.
Do you have $8,000 that you could borrow from anybody anywhere?
No, sir.
Do you have $8,000 worth of property that you could sell and make this bond? $8,000. Do you have that anywhere?
No, sir.
At the time that you went to jail, did you have a minimum wage job working at Church's Fried Chicken?
Yes, sir.
So basically, working at Church's Fried Chicken, minimum job, you would probably qualify for some kind of a federal financial aid or something, right? And then as far as a house, apartment, home, you don't own that, you live with your mama, right?
Yes, sir.
So as far as the bond being sufficient for you being able to appear in court, actually the judge could lower that bond from 65,000 to a lower number, because specifically under the rules, when the state of Texas asks for a bond review, and the court pointed out in the prior hearing, the court could actually determine that the existing bond is excessive. So based upon what I read in the court reporter's notes, Judge Stevens can say that that $65,000 bond is excessive because of your financial situation. Is that right?
Sure.
So at the end of the day, I told you I wasn't going to ask you anything about the case, right?
Sure.
And I didn't ask you one thing about the case, right?
Sure.
But in terms of MONEY, a $65,000 bond would be excessive for a man who doesn't have a job. He lives with his mama. He has no property that could be sold. And I think, you know, and I let Axford to take judicial notice. I think his age is 23 years old. So a 23-year-old man, no job, no. When I say no job, you can't work at Church's Chicken if you're in jail right now, right?
Sure.
So you done lost the Church's Chicken job, which is a minimum wage job, right?
Sure.
And at Church's Chicken, you basically frying chicken and doing stuff like that. Is that right?
Yes, sir.
So are you asking the court to do what it can do, which is lower the $65,000 bond to, let's say, $10,000? He can lower it. You understand that? Right? All right, that's all I asked, and I told you I wasn't going to ask you nothing about the case.
Anything to say?
Not on the financial judge.
I find the, anything else? I find the bond, the setting that the court made based upon his criminal history and the probable cause affidavit, the circumstances to be fair and appropriate under these circumstances. And I deny the request, and we will set this for.
I don't think it's been indicted.
Yeah, once I guess there's an.
It's been received. It's coming up.
Okay, when the indictment comes, we'll try to get a setting as soon as possible, and then you can resubmit your request.
All right, thank you, Judge.
Thank you. All right, let's go to Calvin Walker. Thank you.
Morning, Judge.
Hello, sir. Thank you for waiting.
Yes, sir.
Mike, I think it's bad.
Why?
Something's on.
Who's here from the state? Anybody? Mr. It's just like that. This is a review. This one comes from where? Of status. The court has received a report from Ms. Hunter in this case on the status and.
Hey, Judge, can I bring them to the back if you don't mind?
By the phone.
Oh, that's cool. Thank you, Judge.
A report stating that the defendant has limited income and as of today has paid $13,132.25 to restitution toward the Beaumont Independent School Districts, but over $1 million still remains to be paid on this restitution. And I want to ask, how are we doing on trying to raise our monthly installments? Is Mr. Walker able to pay more while we are awaiting the appeal decision from the appellate court?
Correct.
Go ahead.
Judge, one thing, I don't know how we're going to do it, but he has not been credited for those properties, I don't guess, that he signed his deeds for a couple months ago.
Can you go out? I don't.
But just, I noticed that when I heard that amount, so I raised that. He's got another $1,000 for this month's payment. He recently started working with one of the home contractor insurance companies, and he actually got a couple jobs. I think it was Home Shield, but it might have been the other one we discussed.
Choice Home?
Yes, sir. It was one of those two. I forget which one. But then that's actually been interrupted a little bit. He's had some sort of heart issue going on. I believe Ms. Hunter has documentation of his doctor's name and appointments that he's got. They're not sure if it's not a heart attack, but they're basically doing stress tests on his heart and trying to figure out what's going on, which has interrupted the work for a few weeks now.
Is Mr. Walker able to pay more than $1,000 a month? That's
not this month. No, that's for sure.
What about next month?
I couldn't tell you, Judge.
Okay. All right.
I don't want to mislead the court in any way.
As far as your statement, he will be allowed credit for all.
Yes, sir.
It's allowed by law, and those properties, I'm not sure where they are in the process. But the order was met. Those properties are, I think, in the hands of the Beaumont Independent School District to do as they wish, and he will be given credit for fair market value for them.
Okay.
But I'm more concerned.
Judge, fair market value minus what the tax liens were on it, because there was this, well, I've been told there was a substantial amount of tax liens that were levied against all the properties.
When we say fair market value, of course, you've got a net on a cost. Somebody's going to have to pay for those, and if it's because of Mr. Walker, then he's not going to get credited for that debt obligation. Somebody else ends up paying on his behalf, not him. But
I just want to make a brief statement. Whatever it is we discussed 3 months ago, whenever we signed those deeds, that's what credit we would be asking for. And I don't want to get into all of it today because I don't quite frankly remember. But I think just under the notice provisions and everything that we have in our constitutions, whatever it is we discussed, we would just like it applied at some point.
Hold on, but I'm just going to, this court's, not that this court's spent a lot of research on this, but his indebtedness is not going to be an obligation that the victim should have to endure and pay for. It will be credited on the net amount of the value. That's only, I believe that's just an understanding of just independent fairness. If there were indebtedness, tax obligations, those were his. The victim has already been victimized by Mr. Walker by a jury decision. I'm not going to victimize him again, but pay for his indebtedness. That's just a statement
And
Right. And I'm trying to preserve, we're in murky waters here,
All right.
you know, and I'm just trying to preserve that we made an agreement with the
Okay.
court a few months ago, and we're just asking that whatever that agreement was, it's on the record that he get that amount. That's all I'm saying.
Okay.
I
I wasn't part of that agreement, and I didn't want to be, part of it. But when that agreement was said, there was an amount that was represented to the court, and the tax liens were not represented to the court.
We didn't represent that. I'm sorry, but we didn't represent an amount. So.
I'm not incurring any ill will on your part. I'm just saying it wasn't.
Okay.
And
That's
so,
not an issue that we need to address today, but
okay.
There's just the victims are not going to be re-victimized.
Oh, I'm fine with that. I'm looking out for Mr. Walker.
Today, what additional information do the parties want to add? And I would like to, where is the appeal status on this? Or is all the briefing done and before the Court of Appeals?
Yes, Judge. So Mr. Nealon submitted his brief, I think, since the last time we were here. And then I don't even think I got an extension. I filed our reply briefing timely. It was a pretty extensive brief from both parties.
So it's in front of the court right now.
Right. We don't have any submission schedule yet, but everything is there for the court at this time, Judge.
Okay. What state have to say? Anything else you want to add on this?
No, Your Honor.
Because once I'm still concerned whenever Mr. Walker is able to pay a dime more than what he's paying right now, I want to be able to get that accomplished.
Yes, sir.
All right. And the defense right now is submitting that $1,000 as of today is all he can continue to pay per month. Based on days.
He's going to go pay his monthly $1,000 today. He was put back, so he'll be up to date today for that.
All right, that will be done today, sir. All right. What else? Stay.
Nothing for us.
I think we're in recess on this. Thank you, and awaiting an appeal decision.
Thank you, Judge.
Thank you.
Or no? Did they send it to us?
All right, you have a
She works with.
Oh, you're good to go. Thank you.
Thank you. Bye-bye.
All right. Oh, yeah, his in and out, like I said, I thought it was him, but it's at our end and I don't like it. Good morning, Ms. Conley.
I'll say hi to you. Too big, sorry. Jesus, sorry.
Good morning.
Morning.
This is file number 26372 SM. Are you Elizabeth Conway?
Yes, sir.
And we've met multiple times. You were charged with unlawful use of a 911 call. You've been in jail for 18 days. The prosecutor is going to dismiss this charge, so you're going to get out of jail this morning.
What I want to know is where you're gonna go. Have you got a place to go?
Yeah, I do.
Where is that?
I forgot where, remember when I was staying at 117 7th Street? If you turn left at Pearl's, is it Pearl Street? Turn left
Yes.
at 7th Street from Pearl. It's like a couple blocks up on the right. And then I go to my Aunt Brenda's in Constantine.
Well, you told me the last time you were gonna go to your Aunt Brenda's.
She said go to the garage and sleep, and then I was like, well, I already called the state trooper come pick me up. So the state trooper came to give me a ride because she works midnight, and then my cousin works like second shift. So she said I could already sleep at the garage, it's heated and everything, but I was like, no, it's all right. I'm already gonna go out. And then when I came back the second time, my Uncle Buddy was like not in a good mood. So I was like, I'll just not go here for right now. So that's the only reason why I didn't stay out there. I'd rather stay out around family than around strangers, you know?
Yes.
Plus, yeah.
Are you connected with Pivotal right now? Are you getting any services?
Pivotal I tried to do, but I think I had to do a video visit or something because I can't, sometimes that bus line doesn't work for me.
Are you talking with Lauren out at the jail?
The one lady here, I said hi to her yesterday.
All right, but she's not giving you any treatment?
No, I already get treatment.
All right, who's doing your treatment?
Doctors.
All right, who is that?
They're giving me Seroquel because I asked for that. And that's a part of the psych med.
At the jail or?
Yeah, at the jail too.
All right, I'm reluctant to just throw you out on the street because you've got some significant mental health issues and I don't think you're addressing them very well. But the prosecutors agreed to dismiss this charge, so I don't have the right to hold on to you anymore.
Right.
Do you need a bus pass to get home?
Yeah, actually, can you do that? I think I got one for $1, but I don't know how much they are.
Oh, they're $1 million each.
Well, I got money. I got paid today, I think.
No,
I gotta figure out if I brought my charger or not, you know?
I've got a number of very generous people that have provided us with bus passes.
Okay.
So there is a bus pass to get you back to Constantine.
All right, thanks.
Now, let me tell you this also. When you get upset or distressed, you can't call 911 and vent your frustrations. It ties up the lines for emergency work and you can't do that anymore. Do you understand?
Yep.
And you got a place to go.
Yeah. Yep.
All right. Well, there's your bus pass. They're going to take you back to the jail. Maybe you'll get lunch and then you'll get out.
Okay.
All right.
All right, thanks.
We had a lady a number of years.
She brought these with her.
We've had several over the years, but this lady's name was Marty. Her phone was turned off and the only thing that worked was 911. So she would call 911 every day and tie up their time. I think she's passed away. And then we had another man named Mr. Cootiebug. He was lonely and he would call 911 just to have somebody to talk to, but they got better things to do than provide counseling services in the middle of the night to people. I am concerned, Abigail. I wanted you to see Miss Conway. She's been struggling. She spent much of 2025 at the forensic center. Was much better at the end of that stay, but she's not doing well. All right, according to her, she is plugged into some doctors, but this matter is dismissed on the record. Is that correct?
Yes, Your Honor.
All right. And I wanted to get her out of lockup and back out to the jail so she could be booked out. Thank you, Abigail, for your help this morning. All right, John, while you're in the hot seat, let's just keep going here. Jaden Corbiel. This one we're going to set for last pretrial.
He's going to resolve his ordinance cases
Okay,
But the state of Michigan case is gonna go for a last pretrial.
all right. Mr. Corbiel, why don't you have a seat? I got contact earlier this morning from, Aaron Gushwent on the behalf of Village of White Pigeon. You're charged in this file 2631738 for driving with a suspended license and no valid license plates. The Village of White Pigeon has agreed to dismiss both of those charges if you plead to allowing another to violate the motor vehicle code. That's under statute 257326. That is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. Carries no points, and it doesn't go on your driver's license, so it won't affect or get abstracted to your license. Understand?
Yes, sir.
All right, so that'll take care of the ordinance case. You have another charge of no insurance under state statute. We're going to set that for last pretrial at another day. Is that correct?
Yes, Your Honor.
All right, very good. Mr. Corbiel, did anybody threaten you to get you to plead to this charge
No, sir.
or promise you anything?
No, sir.
You heard me go through the advice of rights with the last gentleman. You understand you have those same rights?
Excuse me, you want him to, I have one in front, you want him to sign one?
Hell, I haven't signed it anyway, but he heard me say it. He was
Yes.
sitting there in the back.
Today is the 27th of March.
All right. The other one, that's a pretty good deal. The village attorney allow 257,326 in 26317 and 8. Dismiss DWLS. And no plate. Now, let's see. These were on the same date, February 21st. All right, were you driving a car? Let's take a look at your ticket. I fear for Miss Conway's safety. She needs a place to be. According to this ticket, at about 7 o'clock at night on February 21st, still snowy. You're at Chicago Drive and Miller Road, Chicago Road, Miller Drive, going 51 and 35. Was your license suspended at that time?
I believe so.
Yeah, all right. And they didn't give you a speeding ticket, just a warning?
Yes, Your Honor.
Okay. All right, we will set the other case for last pretrial.
I mean, part of our rationale is he's suspended, we believe, for points, and his points are going to be going off. And it's our belief and understanding that he should be able to obtain a license before the next He's suspended because he has $1,676 with unpaid fines and costs. Careless driving, 2023, he owes $156. Registration plate, 2023, he owes $210. No proof of insurance, 2026. He owes $150. Failed to yield, 2023. He owes $120. Registration plate violation is $120. Improper use of traffic lights, 2024, he owes $125. Impeding traffic, 2024, $105. No proof of insurance, no proof of insurance in 24. Driving out of cycle endorsement, defective equipment, failure to yield, and a speeding ticket. You have multiple traffic citations that go back to 2023 that you haven't paid. Does the record reflect you had made some payments in the last month, John? All right. Where were you going?
I was on the way to drop the truck off at my dad's.
Well, I'm gonna waive your attorney fee. I'm gonna waive your fine. You owe so much money now. Crime victims' rights fee, $75, $50 state minimum fee, and 7 days in jail, starting right now. You can't keep doing this. There's a consequence. So you're going to jail for 7 days, and then you can make your payment plan when you get out. Keep poking me in the eye with a sharp stick. You got impeding traffic. You got no proof of insurance that will reduce for something else. You blew them all off. I got on your case at the time of your arraignment. But there's a consequence. I'm probably not going to put you back in jail when they resolve the other case. But you got $1,600 with unpaid traffic tickets. So we're not going to do a fine. $125 is the minimum fine or 2 additional days. I'm not going to chase you for that. You can't keep doing this. About once a year, I put somebody in jail for this. It's very rare, but you've earned it. So you can go with the officer for the next 7 days. When you get out, you can continue to pay on this. So we'll set a pretrial on your other case. All right, we'll do a last pretrial on the other one. And I'll stop if we're driving. All right, who we got left here? Tyler Hostetler. Last I knew, he had not showed up. He is not here. There's a domestic violence charge. I have not heard from him. Mr. Hostetler also has multiple unpaid fines and costs. amount of $966, including a previous domestic assault. Failed to appear, bond is none. Well, I don't think I can do that. $10,000 cash or surety. No 48-hour hold. Tyler Hostetler has a previous unpaid domestic violence. He has several other unpaid matters. And he's failed to. Have you had any contact with him?
I haven't. I sent correspondence to him on March 13th to a Lutz Road address. Wanted a copy of the police report and asked him to contact me.
All right. He's still around. So we'll have to get him in here and get the case back on track. Then we've got Sandeep Singh. Then we've got Rhonda's cases. Good morning, sir. Are you Sandeep Singh?
Yes, I am, Your Honor.
I met you at your arraignment. At least you don't owe me a bunch of money. No, that's good. People have been less conscientious about paying fines and costs as the consequences have been reduced. You talked about this charge at your arraignment. You got charged with embezzlement, over $200, but less than $1,000. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000, $2,000. According to this, they're recommending placing you on a probation under Holmes Youthful Trainee Act, which means if you successfully complete the probation, the charge could be taken off of your record and made non-public. How old are you, sir?
I am 23, Your Honor.
All right, you're eligible for that up until you're 26. Where'd you go to high school?
Constantine?
All right, that's what I thought. Did your family own a business there?
No.
I thought, okay. I mean, I got the wrong. Singh's a very common name.
Yes, it is, Your Honor.
It's like Jones or Smith in English. All right. Anyway, the allegation is that you took some money while you were an employee at Myers without having permission to do so. And nobody wants an embezzlement charge on their record. That doesn't do very well when you're applying for your next case. Embezzlement is larceny when there's a relationship of trust with the other party. So if you went into Myers and stole $300 worth of stuff, it would be charged as larceny over $200. As an employee of Myers, it changes it. The punishment is the same, but it becomes an embezzlement charge. So the probation here would be important. Other than what's been said here about the recommendation for Holmes Youthful Trainee, has anybody promised you anything to get you to plead to this?
No, Your Honor.
Or threatened you?
No, Your Honor.
Now, you've heard me go through the rights a couple times this morning, and I don't think I have one from you. But did you understand you have those same rights?
Yes, Your Honor.
All right. Were you working at the Myers store?
When it happened, yes.
All right. Let me find the affidavit. There is no affidavit. What was your position at Myers?
I was a service coordinator.
And what is that?
It's pretty much like a supervising cashier.
This case involved the bottle return slips, as we often see in embezzlement.
Yes,
cases.
Mr. Bush and I have been here the same amount of time. We've seen 100 bottle slip cases, probably literally. So were you using return from bottle slips to take cash that you kept for yourself?
Yes.
More than $200?
Yes.
And did you lose your job as a result of this?
Yes, I did.
I appreciate your candor. You're owning this, which is a good sign. I'm gonna have to set this for sentencing because I don't know anything. I don't know, I don't have an affidavit of probable cause. You don't have any criminal history, as I recall, none. You've not been in trouble before. You're young enough. You feel like you're appropriate. At one time, I started this when I was the prosecutor. I had an embezzler's treatment class, which I was very proud of, particularly for women. It was a very good treatment program. And when I became judge, it sort of faded away. Circuit court quit using it altogether. Anyway, we've got some lesser thing. Are you working somewhere now?
Yes, I am.
Where do you work?
The Shell in Vicksburg.
He is in a position where he would like to move up, but this is kind of him.
Yes. Well, they're about to that's a nice station, but it's too small. The parking lot's too small, and apparently they're gonna revamp the whole thing.
Yes, that is what all of us have been told, either next summer or the.
Well, I heard it on the radio. They're gonna they bought the house next door, and the plan is to move the building and leave the pumps and make it all bigger, but it's a nice station right in Vicksburg. All right. Well, let's pick a date. I'm gonna need a police report, restitution. Information. Well, let me see if you're set to be here.
Can we use that May 4th we used earlier, or is that for?
I think we can. That'll just about fill it up, but you're already scheduled to be here, so we'll set it for May 4th. At 10:30. It sounds like you've come through this pretty good. I'm going to hide a wreck. Once it becomes Holmes Youthful Trainee, if I do elect to do it, it'll become non-public. So I'm going to do it on that day, probably not making a live stream of it.
Do you want me to file a written HIDA motion? Your Honor?
Yes, please, that would help. That would be on Monday, May 4th, 2026 at 10:30. All right, Mr. Singh, I'll see you at that time.
Does he need to talk to anybody before he leaves today?
No, I didn't ask for a pre-sentence, just the police report and restitution issues. If there's anything you want me to know, Mr. Singh, bring that with you and share it with your lawyer.
Thank you. I believe that covers everything for me.
All right, thank you. Let's get Rhonda on her way. They're moving here. Oh, bang, crash, boom. The whole courthouse is in disarray. All right, thank you. Let's take Miss Sharp. We'll do that one. We didn't have 70 cases today. We had 16. I think we're gonna take about 8 or 9 things, which still takes a while. Well, our friends from up in Alpena are gonna come visit. I'm just amazed that they want to use their spring break to come down here, but several times. Let's see them. All right, are you Dixie Sharp?
Yes, sir.
File number here is 252729. You're charged with operating while intoxicated, possession of open intoxicants. You heard the earlier one. Operating while intoxicated is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be dismissed. The prosecutor in your case has agreed to dismiss both the operating while intoxicated and the open intox charge. First case, misdemeanor. I tried a felony case before I actually tried a misdemeanor. First case I ever tried was a OUIL and open intox. And that was a long time ago, 1981, maybe even 1980. I think it was 1980. I must have done it when I was an intern. You heard me go through the advice of rights. They're going to reduce this to a charge of impaired driving. Let's talk about that. Impaired driving is punishable by up to 93 days in jail and a fine of up to $300. It carries 4 points rather than 6. And the important thing is it allows you to keep a restricted driver's license, to drive back and forth to work. The other one just suspends your license outright with no driving. Do you understand?
Yes, sir.
Anybody threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No.
Let's take a look at your ticket. Got a lot of files open here. Let me close them.
And I would indicate that my client has indicated that she did have some alcohol before driving. She also had some alcohol after driving. I had questioned her whether or not she might have a good defense at trial, because it's hard, when you have got these cases, what was the actual level. However, I think reducing this to impaired makes sense because we don't really know what her actual level is going to be. So I'm not really sure if using them.
We'll try to sort that off.
Okay.
Where do you live?
I live in Florida.
All right, Crawfordville, Florida. How'd you happen to be here?
My family lives here. I was born and raised here.
Okay, where?
Sturgis.
All right, so you're staying with family till we get this resolved?
No, I'm traveling back and forth. I'm pregnant and I have doctor's appointments. Yeah, I just found out like a month ago.
Well, this was December. Were you pregnant in December?
I didn't know, but yeah, I was pregnant. I didn't know at the time. Absolutely wouldn't have been drinking if I would have known.
So you're not drinking any alcohol now?
No.
All right, this was out in the country, out by Glen Oak, Sauger Lake Road and Bulk Road at about 10 o'clock at night on just after Christmas, December 27th. Where were you going?
Home to to my mom's house.
Where does your mom live?
Huff Road.
All right, well, it's twisty and turny out there. It was snowy. Did you have an accident?
I did not. I pulled over on the side of the road. I got lost. I didn't know where I was at. It was foggy and I hadn't been in this area in so long and
Well, how did the police just came upon you?
yeah.
All right, that's not all right. So what were you drinking?
I had Tito's.
Mixed with something?
No.
That's a red flag when people are drinking vodka straight up.
Yeah.
December 27th was a Sunday night, but straight vodka is a big, let's take a close look at this. Sounds like you were self-medicating. Where were you coming from?
Kalamazoo area.
You drove all the way from Kalamazoo to there?
Yeah, but I wasn't drinking. I had 2 shots and then I drove. And then when I got stuck is when I drank more.
Well, for impaired, we have to find that as a result of the alcohol, you were impaired your ability to drive. You were lost, you pulled over because you couldn't negotiate it. So we'll try to explore this further as sentence. Where were you in Kalamazoo?
I had been door dashing.
Okay. Did you drink at a friend's house or anything?
No, I stopped at a liquor store and grabbed it on the way home.
As you're saying this now, you know that is not a good plan. What do you do down in Florida?
Well, I was door dashing. I'm a stay-at-home wife. I take care of the house.
For someone who drives, getting a suspended license is a big deal. There goes DoorDash.
Yeah.
I guess an impaired license would allow you to drive to, from, and in the course of employment. And if DoorDash is your employment, I guess it would let you do it. We've got to push this out a bit. Miss Ives is going to be gone for a while. I'll set this for October when she's back. Maybe sooner. How about May 11th? Does that work for you, Rhonda?
Going by my calendar, I turned off my phone because for some reason I can't figure out one particular setting. When one person sends me a text, I can't figure out how to turn off that particular volume. And it's just very irritating. And it seems to that person sends me a text right when I'm in here. So I apologize.
All right, stop texting her.
Yes, thank you.
Jackson keeps sending you a text and it makes your phone go off. He's pleading the fifth on this.
I don't even know if he knows how to answer a text, Joanna.
Monday, May 11th. Does that work for you?
That sounds like that's going to be a good date. That will be fine.
All right, and if we get more cases for you, we'll try to set them for that same day.
That will work just fine. What time are we using?
11.
Perfect, thank you.
All right. Ms. Sharp, this will give you time to go back to Florida and come back again. It starts to get real hot in Florida. We have reverse migration. Florida people come to Michigan in July and August. And I'm gonna need to find more information. I'll get the police report, your driving record, find out what's going on with you. I will tell you right now, in light of the fact that you're pregnant, it's very unlikely you're gonna do any additional jail time unless you keep doing this. So I don't want you to drink anything while this matter is pending. All right, I want you to take this out to the counter. Let me give you the rest of the file here. All right, Ms. Sharp. I think you're more aware of what's going on now, but something was going on in December. We're gonna see if we can get to the bottom of it. All right, you're free to go. All right, Mr. Swinehart, would you come forward?
Best for last, huh?
Yes, you were the first one here, so somehow you ended up being the last.
Yeah, I usually am the last one. Sorry.
All right, well, every time somebody has to be last, I'm sorry it was you, but thank you for your patience. All right, this is People versus Ryan Swinehart, file number 261760T. It's ordinance case. Mr. George has discussed this with Ms. Ives, and the defendant is gonna have his charge of driving suspended dismissed, and you're gonna plead to no valid operator's license. Do you understand?
Yes, Your Honor.
Take a look at your ticket. Let's talk about that. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail, fine of up to $500. It carries 2 points on your driving record and requires that your license be suspended. This was at 1:10 in the morning at Main and 4th Street.
Yes.
Now, they're going to dismiss that charge for a plea to no valid operator's license. No valid operator's license is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It does carry 2 points, but it doesn't require that your license be suspended. Do you understand?
Yes, Your Honor.
You've signed the advice of rights. You've heard me say it about 3 times this morning, but you understand you're giving those
Yes.
up. Anybody threaten you to get you to plead to this?
No, Your Honor.
Promise you anything?
No.
Where were you going?
So I was coming back from the shells on 131 because the shells on Main right there they went on break and it was cold outside, so I was like, I'm just gonna go to one uptown instead of wasting 15 minutes waiting for this guy. And then as I was coming through the lights from Maine, the officer was coming down the street and I was going 10 over. And then,
All right. Did you also have a medical suspension or just all these points?
So all those points were from when I was younger. You gave me all those points, actually.
I did.
You yourself have, yes, sir.
I also gave you lots of fines that you haven't paid.
Yes, Your Honor.
$1,794.
I would like to make a payment on them today. I just haven't been able to,
How much? Of like $1
at least
million?
$100, at least $100.
Disturbing the peace, open intox, no proof of insurance, impaired driving, speeding, retail fraud, disturbing the peace, and disobeying a stop sign. I put the last guy in jail for 7 days. That probably made
Yes,
the
sir,
hair
I heard
stand
you.
up on the back of your neck. Why shouldn't I put you in jail for 7 days or 70 days? Are you working someplace?
No, but I put in like multiple applications, especially this year. I've just put in one to Morgan Olson. I did one for a CNC operator, which I got denied on. And then just trying to get out.
Well, what were you getting at the store? Cigarettes or?
No, I was just a black and mild, single cigar, just $1 cigar.
You're driving around at 1 o'clock in the morning for one cigar. Your license is suspended. You know
I
it.
was unaware. I was unaware of that.
Yes, you were. Do you have a plastic license?
Yes, sir.
I can see it. It expired February 17th.
Is it expired?
Yeah, it's expired.
Oh, I didn't know that. Well, I haven't been having a reason to use it anyway, so.
Well, you weren't expired on January 29th.
Right. So I haven't been home at that point for a couple of weeks. And then the day after I got pulled over, I found a letter from the mail for the suspension.
Well, they gave you a restricted license.
That was you. And then that case was over. And then you lifted
SOS
it.
from May 29 to August of 29. Then they made a referral for an exam. Did you go to a hearing at the Secretary of State?
What date?
Last November? January 16th.
No, Your Honor.
Reexamination date, January 16th, 2026.
No.
So this was, maybe you didn't know you were suspended.
See, and I wouldn't have.
All right, I get it. I think the thing, they suspended you and then the time was.
Thank you.
All right, I'm gonna put you on a payment plan. I want you to pay $100 today.
Yes, sir. Thank you for not putting me in jail.
All right, well, nobody wants to go to jail, but
No,
I want you to, there is an issue regarding, you did show me a valid, it's expired right now.
Yeah,
so-
I'll take care of it.
Well, you can use it for ID purposes.
Yes, understandably.
But right now you're suspended by the state as of January 16th.
Is there a way to work towards that, or do I just?
Well, I would contact the Secretary of State's office.
Okay.
You get, all that stuff happens not from the court,
No, I understand
but
that.
from the driver's license appeal division and the
It's
Secretary
from
of
me
State,
yielding at the stop and not paying the ticket,
among other things.
among other things. Yes.
When did you last work?
Well, I did a car last week,
Well, I
but
mean, you seem pretty capable. It seems like somebody'd hire you somewhere.
and that's the thing. I put in over. I can show you on my phone. I put in over 30 job applications last year, and I had zero progress.
Well, maybe do some in person. All right, no jail. I'm gonna just lower. You already owe so much. I'm gonna make the fine $100. I'm gonna waive your attorney fee.
Thank you, Your Honor.
So you owe 275, 225. I don't want to short the city of Three Rivers. $100 2-day payment plan. The difference between you and the guy that's in jail for 7 days is you did actually have a valid license till just before this happened.
Yeah, I see, I tried to keep everything, especially with traffic laws, because you know how it can get.
I sure do. I call it the driving suspended merry-go-round. You get on it, you can't get off it.
Right.
Well, you're on it. Don't drive anymore till you get it straightened out.
Right, I don't got a car right now anyways, so I got to go.
All right, Mr. Swinehart, you go with the court.
Thank you, Your Honor. Have a good rest of your
Thank
weekend.
you. I hope to. Thank you. Thank you, Rhonda, and good luck. I'll see you on the other side of your trip.
I'll be married.
You'll be married by then. I enjoyed meeting your fiance. He seemed like a good guy.
Yeah. Yeah, he's the fun one.
Tell him to quit texting you during court. All right, I believe that completes our morning. I think that was 1, 2, 3, 4, 5, 6. I think we took about 9 pleas, which is better than a poke in the eye. All right, we will be back.
Plaintiff.
Why don't you just tell me?
I'm Stacy Allport James. Paul is dead and my son doesn't live with me anymore.
That's right.
She's one of the ones on our sheet, Amy.
Oh, is she?
Yep.
Where-
It's under your counter.
Just put it a different place on her. Never mind. I didn't say that out loud. Okay, got it. Okay, where are we on this case? Because I have some information.
Sure. Right now, the rent to retain is 1665.58. There's cost of 271, so the total is 1936.58. Just for the record, we are dismissing as to Nathan Allport and Paul Cochran, so it's just relevant. I do this with off on a consent judgment. Sounds like she's going to be getting sentence as well.
On today's day, approved application, your total amount was 1930.58.
Yeah, and they paid,
They pay?
well, they're paying. Hawk approved my payment and they said it would be there within 2 weeks. And on
Right.
top of,
Now, I got you, but these numbers don't match. Did you pay something?
no, I didn't pay anything yet.
How much is your monthly rent?
733. What would the site?
733?
Yep.
Can you give me 1936.58? 733.
It's a 1936.50.
8.
Minus what?
No, not minus, plus 733.
I have our ledger too, if you want to look at that, Judge.
669.
2,600?
$69.58.
Okay. So what I have here is that you've been approved for 2591.58.
Yes. Because they wanted to pay April's base rent.
Yeah.
Yeah,
That's what I was for.
but the extra court costs and the water, sewer, trash,
What they're indicating is that you've been approved for that amount.
Mm-hmm.
You need to still pay your utility fees when they post to the ledger.
Yes.
And tenant and leasing officer notified and made aware of payment expectations. So I'm a little, I mean, I'll enter the judgment. What I don't want them doing is coming back and saying, now that's what you owe. You know what I mean? I would almost rather put it out to my next date of April 10th.
Okay.
I've got the information. I think your client also has the information that this is what they're going to pay.
We do.
Just have to make up the difference. And if I do that and they pay, this matter can be dismissed instead of a judgment.
Okay, okay, that's fine.
With that,
Yes.
okay,
better.
I would feel better doing it that way, so I'll give that back to you, Stu.
No problem.
Okay, side stuff. No, I mean, no, I wasn't saying anything about you, man. I'll adjourn this to April 10th, 2026 at 1 PM. Okay, so if that check comes in and you pay the other thing, you may not need to show up. Everything's,
Okay, so just email the court like I did this morning and ask if I need to be here.
I don't know what they told you. They probably told you yes. That's probably
I
not.
didn't have a dismissal to show up.
Got it. Let's get back with that.
Thank
Okay,
Thank you, Judge.
thank you. Clark Road, Family Dividend Housing versus Jesse Wilson. Okay. Go ahead, counsel.
Good afternoon, Rebecca Arnold, P72714 for the plaintiff. This is for non-payment of rent. We have rent to retain in the amount of $2,862.72. Court costs in the amount of $239.72 for a total of $3,102.44.
Your name?
Jesse Wilson.
What was your base rent, counsel? On those numbers you gave me?
The base rent?
Yeah, the rent that you, prior to the court cost, was it 2862.72 or something like that?
Oh, yeah, $2,862.72.
Got it. All right, we're gonna pay $700 or so. What happened?
My car got repoed last Friday, the day that I was on Zoom here in court.
Okay. And you had to go.
And I had to go to Ohio and get it back the same day. So that was the money that I was going to give them.
Okay.
I literally was getting off of Zoom and they was pulling off with my car. So
how were you intending on trying to get this paid? Because
I get paid April 3rd. I've been doing 12, 16 hours a day just to cover this. My car was down in February for a whole month and I'm just be behind. So
no, I got you, but
I've been trying to catch up.
So April 3rd, though, you're not going to have this full amount, right?
No, that's a full check. And then from today up until April 3rd, I can have an $800 plus the rent. I mean, plus the full check that I get on April 3rd.
My concern is that rent will be due again on April 1st, and that's another $1,323.
Right. No, I get that, counsel. I'm just trying to figure out.
Right. So April 1st, that'll be due on April 3rd with that check.
Hold on a second. Between how much money do you think you're going to be able to come up with between now and April 6th?
$2,000.
$2,000. And then you got another 1,000 plus another 1,000 or so for your rent. How are you going to get that paid? I mean, because that's going to be another $2,000 plus.
Working, I've been doing 16.
No, I hear you, but is there going to be a check that's going to be able to pay that $2,000 plus off? Don't know.
No, not right now.
Here's what I'm going to do. There's no tribal issue for me. And after hearing in this case, I'll grant a judgment for possession for that total amount of $31,0244. Was it, counsel?
Yes, that's correct, Your Honor.
All right.
So
And-
I think we requested a possession and a money judgment.
Yes, and I'll also grant a money judgment in that amount. Young man, let me. So what it is you don't get paid this Friday, right? Is that you get paid every week or every other?
Every
Every other week. So when you say the 3rd, that's your check.
Yes,
For, and then you don't have another check until the 17th.
correct.
So what I'm going to do is I'm going to do it this way. All right, yeah, and I'll try to give you a way to do it, but you got to do your part here, okay? Because I'm going to grant the judgment, both the possession and money judgment. I'll indicate that a writ will issue April 6th, which would be the 10 days. But if defendant pays $2,000 by April 6th, then the writ will be extended and he's to pay the balance of this judgment plus his April rent. I'll give him to the 20th. However, you're going to come up with that. That gets you your next check. You follow me? That I don't know if the math is going to work out for you, but at least give you a shot. But you got to get that $2,000 into them by the 6th. And that's going to buy you basically another 14 days to work, put together money, pay your April rent plus that. Otherwise, then they can order the eviction.
Understood.
Fair enough. All right. Give you a shot here.
Thank you.
All right. Good luck. Court calls the case of Clark Road Family Limited Housing versus Anastasia Wright. Hello.
Hi.
Name?
Anastasia Wright.
Okay. What we have is the balance count.
Well, and I may have to have my community manager chime in on this. I had a balance of $1,283 in rent to retain, court costs of $239.72 for a total of $1,522.72. However, I believe Miss Wright may have made a payment this morning, and I may not have that on my current ledger.
Okay, what'd you pay?
I made a $500 payment today.
Okay, you made 500.
Correct.
So that
Okay.
takes the rent to retain it down to $783, I believe.
7. Well, with cost, you gave me 1522.72.
Yep. So with costs, that's down to $1,022.72.
That's correct.
Okay.
Okay, that's. I was like, what kind of math are you doing? Okay, 1,022.72 with your payment. Okay, let me ask you this. Okay, when do you think you can get that in?
So I sent the email requesting a conditional dismissal. If I was to pay $500 this weekend, and then the remaining of this month's rent, because this is for March's rent, the remaining of March's rent by April 11th, and then the full amount of April's rent by April 25th.
Okay, so I just want to make sure I'm hearing you, okay? You paid 500 and you're gonna pay another 500?
Correct.
Okay. And then, so then you'll be down to like 522.72 on this.
Yes.
Monthly rent is how much?
$1,733.
Got it. I think you told me that, right? Or 1763 maybe.
Yeah.
Okay. And so that kicks you back up around needish, because that's gonna kick you back up to around $2,000 that you owe.
As of April 11th, that would be the balance, correct?
That 14.772.
Oh,
I have the current.
hold it, hang on. 14 what?
With the 500.
Okay, so council, just that number that you took down is likely, it's about 100, well, whatever off, but I think it might be your $75 attorney fee, which is not on their ledger. Cause
That's correct.
cause she posted in the chat that her balance is actually, after the $500 is put in, 1447.70.
Okay, so on my current ledger, well, that's what I was curious, because I do have 1477.72 minus the legal if we subtract out the legal fee. There was a $500 payment made on the 23rd, and I wasn't sure if there was another payment made since then.
This morning, I have the receipt here.
Oh, you paid one this morning?
Yeah, I have a receipt right here.
Okay.
Here you go.
So,
And that's what I don't know if my property manager can confirm if there was a payment this morning or not.
Sharon was on it.
There was a
Payment of $500 today.
Okay.
got it. So I guess we're trying to figure out, and because now I got numbers all over the place here. I got 1522.72, which was the first number that council gave me. And there was a $500 payment today. You gave me 1447.7 or 1447.22 or something like that. I get
that 14
that
includes
that's without the attorney fee.
That includes part of an attorney fee. It includes a partial attorney fee, which I had subtracted out.
Okay, so
How much is the?
hang on. I just what I'm trying to figure out. I'm trying to figure out what is owed. Because then I guess you posted in the chat that she owed 1447.72 after the $500. Is that the $500 that she put in today?
Correct. It's already been
Okay.
posted to her account.
Got it. So you can have that
Okay.
back.
So that's
So-
where the balance is then the number I originally gave you, which was the $1,283. That's the rent to retain without attorney fees. So if you take the 1447.72 and subtract the legal fee of 164.72,
I get the
that gives me the one.
amount would have given me. So right now, what she owes after everything's been taken is the 1447.72, right?
There's a $75 attorney fee and the process server fee that's on there that wasn't on the ledger. So that's where the 239.72 comes from.
So the 1522.72, is that the number that she owes? If you were going to take a judgment today, that's what you take it for, right?
Yes, that's correct.
Okay, that's what I need to know. And they've already applied your 500.
Correct.
Okay. That's what I.
So, yeah. So let me ask you this, ma'am, because you're trying, right? When would you be able to come up with that 1522.72?
So I was gonna be making the additional $500 payment in addition to the one that I showed you this weekend. And then I wanted until April 11th to pay the remaining $1,000 balance.
Got it.
Or March's rent.
Oh, I got you. I got you. Okay, so here's what I'm gonna do.
Okay.
Okay, and
then
I'll
we
explain.
do- Sorry, Your
Pardon?
Honor. I was just asking about how we would factor in April's rent.
Right. Well, here's the thing. I can either do it one of two ways. I can either take the judgment amount and just extend her redemption period to, well, the 11th is a Saturday, so it'd go to the 13th. So I'd extend it out a week. That would not take into account April. Or I can do something like I did on the last case that says if she pays a certain amount, then we can give her additional time to get her April caught up.
Okay. And then my concern is again, that's sort of perpetual, that if we extend her April rent to the 25th, now we're looking at, is May's rent going to be on time?
I hear, and I tell you what I'm more inclined to do, although it may end up, ma'am, costing you more if they have to start another case again and you can't work something with the landlord. What I was inclined to do was just to take the judgment for the amount here, extend your date to pay to the 13th. I just extend it out a week for the time you'd normally have anyway. Let you pay off this judgment and then you got to get April in for April.
Your Honor, in the conditional dismissal request that I sent to the property manager, I stated to them that this rent is from March. I had a $3,600 payment made at the beginning of this month to cover what was owed. And they still continued court anyway for that past due balance at the beginning of March. So once that payment was made, I still had to pay March rent. So it's kind of just taking me a while to pay it because of that.
No, I hear you.
But I
know.
would like to get this taken care of by April 13th, so that way I can focus on paying April's rent.
Okay. And that's what it sounded like as I'm listening to you. It sounded like that's almost the best course. If they want to start another case again, start it for April, we'll figure it out, but you'll probably be able to catch yourself up.
Yeah.
Right? That's how I was viewing it. Okay. So I was just trying to give you a firm number. This is what you got to pay by the 13th. Get that done. Then you can focus on April.
Okay.
Fair enough? Okay. So what I'm going to do, and I don't think they're inclined to do the conditional dismissal, but I'm going to enter judgment for possession and a money judgment for $1,522.72. And then I'm going to make the writ date or the eviction date by the 13th of April. Okay, so that way you pay the 500, then you're going to have $1,022.72. Get that paid by the 13th. You're good on this judgment.
Okay.
And then if they got some issues for April, they're going to have to file again. That you'll have added costs, but it's kind of buying you time to get yourself all caught up.
Okay.
Follow me?
Yes.
All right. Thank you.
Thank you.
Salem One Inc. versus, is that it for you, counsel?
I believe it is. Would you like me to write up that judgment and submit it?
Yes, you have to send the judgments into us.
All right, will do. Thank you.
Thank you. Salem One versus Linda Hines.
Good afternoon, Your Honor. Ian Rudman, P70599 on behalf of the plaintiff.
Said that right here. Linda Hines.
Your Honor, one thing I would like to mention is that on the docket, it's saying that it's a land contract case, but it is not.
I know.
Oh,
think. Yeah. I dealt with the clerks the last time. God. I'm unclear as, oh, never mind. But I got it. I'm clear it's not. Okay.
Okay.
All right.
This is an eviction following a foreclosure. And we filed.
The right hand to be sworn.
Oh, what?
Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God. Go ahead.
True. As an officer of the court, I would always be telling the truth, Your Honor.
I understand.
This is an eviction following a foreclosure. The redemption period expired March 10th of this year, so just a couple of weeks ago. When we filed this complaint, the redemption period had not yet expired, and that's why we filed it with a request to shorten the redemption period because they had failed to allow us an inspection. However, now that the redemption period has expired, we are no longer seeking that request, and we are asking for a default judgment with a vacate date of April 6th.
Here's one that testimony. Judgment to the plaintiff that is by default for possession, no redemption amount, writ to issue April 6th.
Thank you, Your Honor.
Thank you.
Have a nice day.
Carl Mantilla versus Delilah Affleck.
It's not here. Just the
Your name, sir?
Carl Mantilla.
This is a termination.
Yes. My first name is misspelled on the docket, Your Honor.
Pardon?
On the docket, my first name is misspelled. It's Karl.
Karl.
Yes.
Carl.
Yes.
How is it spelled on the docket?
Out there in the hallway, it's spelled Karryl, I believe.
I'm sorry about that. It's correct in my file. So
That's good.
Not sure why that would be.
I just wanted to be correctly identified. That's my only concern. Thank you, Your Honor.
Okay, it's okay. You're Carl. I got it. All right. Yeah, we've got it. It's correct in this file.
Correct.
Which is actually the official document. All right, this is a termination. And I know they were not here the last time. Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, yourself again?
Yes, I do.
Hold on a moment. Is there currently a lease?
Yes. She's held over the lease. The lease ended on January 1st or 2nd, something.
Okay, so the lease is ended.
Yeah, she
Okay,
noticed
fine.
as of the first day of the month.
All right.
before.
You are the owner of the premises.
Yes.
The court, when reviewing the file, there's a proper notice sent to the defendant terminating tenancy. I will grant a judgment to the plaintiff for possession. I do not have personal service, so I can grant no money judgment, but I can grant a judgment for possession, no redemption amount.
I'm sorry, Your Honor. I didn't hear what you said about the money judgment.
I cannot grant a money judgment because I don't have personal service.
Ah,
Don't have personal service on her, so I can't grant the money.
so what does that mean for me? I would have to go to a small claims court or something?
That's what you're gonna have to do.
Okay.
All right.
And I also,
And for possession by default, writ to issue April 6th. Yes, sir.
I'm sorry, what does that mean, Your Honor?
Okay. That means that
I've never done before in all the court terms, except for what I read online.
it's okay.
Are
So you've got this all filed. You'll have to go out, fill out a judgment form, fill out the judgment form
okay.
for my signature. Okay. And then under paragraph 4A or 4B, you're going to put the date of X. Then come April 6th, in order to evict the individual.
Is that the writ of jurisdiction?
That's the writ of restitution or
Restitution.
the order of eviction.
Okay.
I think it's properly called that.
So as of April 6th,
Then,
April 6th, you could pay $15, file that, and then I'll sign off on that.
May 15, okay. And then after that, it goes to the sheriff
To go to one of the court officers to
officer.
accomplish the eviction. Yes, sir.
Okay.
Where's your property located in Northfield? So it's probably gonna go there.
Right.
But one of our 3 court officers are.
Okay. So the next step is filling out that judgment out there and they'll have your signature.
No, they will, once you fill it out, they'll get it to us and then I'll sign off.
Okay. Then on April 6th, I can pay $15 and they will file it with the appropriate authorities.
Then you have to fill out another form
Okay.
called the order of eviction.
Order of eviction. Okay.
And
All right. And I don't know if you're able to answer this, Your Honor, but
probably not, but
I suspect she's not going to give me a forwarding address by which she can be found for finding her and serving her. So how do I or law enforcement find her at some unknown address upon fleeing?
what?
To file the court papers for a judgment against her for the back rent.
I cannot answer that. I can tell you that you can file the complaint and then it's gonna be what everybody goes through or every attorney goes through. You gotta find a way to effectuate service of your complaint.
I see.
Okay.
Okay.
All right. Thank you.
All right. Thank you very much, Your Honor.
You're welcome. Have a good one. Court stands in recess.
Mr. Cooper, click on the invitation to a breakout, and you did. Now, let's see. Will be on the record in Clark, GW 2026 TR 34, State of Kansas versus Jacob Anthony Clark. Paulie Dean for the state. Mr. Clark appears in person and pro se. Mr. Clark, in count 1, you're charged with driving under the influence of alcohol, drugs, or a combination thereof. And in count 2, you're charged with transporting an open container. Excuse me. When you were here on February 24th, you said you're going to apply for diversion. Did you do that?
Yes, ma'am, and I paid the fee. I also did the where they assess what's needed. Yes, and they signed me up for a 1-day class that's in April.
All right, so it sounds like he's been granted diversion, but I don't see that that's been filed yet, Mr.
Yeah, I show that we mailed him the contract on March 6th. Let me see if the notes show we have it back now.
I looked through my mail and could not find it. I also was told that it would be emailed, so that's what I was looking for. I called in this week and they said that they would send it back out and I could get it back in this week.
All right, let's set this over. Continue this at the defendant's request to that July date.
Let's do that. We don't need to go that far. Let's do the May 8th, Judge, if you're okay with that.
All right, May 8th at Missy, when you want him back, 11?
Yes.
All right. If the county attorney doesn't have that on file by May 8 and 11, you're going to have to be back here again, Mr. Clark.
No problem. I as soon as I receive it, I will get it in, Your Honor. I want to get this behind me. So
Sure, and if you don't get it within the time they tell you to expect it, you better be calling them again.
Yes, ma'am. I will go pick it up if needed.
And you made sure that they have your correct address and all of that.
Okay, ma'am. Yes, I already checked with the attorney.
All right. Well, you'll be excused at this time until May 8 at 11.
Thank you very much, Your Honor.
Thank you, sir. You may go.
Thank you. Bye.
Welcome. Jessica Morgan, are you here on a show cause?
Your Honor, I am here for Nicole Gardner. I was just going to confirm that she has signed conditions of probation. I think there was a review hearing.
Yeah, and I received that email from her. It looks like Miss Gardner is there. She was gonna join us.
Well, my Odyssey system has decided to go on a continual buffering. So what's her case number, please?
Her case number is GW25TR 000214.
Thank you.
And I reviewed the journal entry and
let me state it for the record.
okay.
On the record in GW 2025 TR 214, State of Kansas versus Nicole Gardner, Paulie Dean for the state. Miss Gardner appears in person and pro se. Mr. Dean, you were saying that Miss Gardner has been granted diversion?
No, Your Honor. Miss Gardner's non-reporting probation had been previously revoked and reinstated on reporting probation with the assessment of $60 supervision fee. We'd set this over to make sure that she got all of her conditions of probation signed and had made contact with probation, which she had. So that's all we needed to accomplish today, and the matter's completed. She just needs to go ahead and finish her probation. And again, upon payment of all costs and fines, she can request early termination.
All right. So Miss Morgan, Jessica Morgan of probation is here. Has she signed up and done everything she was supposed to as of today?
Yes, Your Honor.
All right, then we will consider this a successful review. Miss Gardner, you need to make sure you continue to do everything your probation officer tells you to do and when they tell you to do it.
Yes, ma'am.
All right, we'll be in recess on Nicole Gardner. You may go.
Thank you.
Thank you. Miss Morgan, anything else?
No, Your Honor, that's all I have this morning. May I be excused?
You are excused. Thank you, Miss
Thanks.
Morgan.
See everybody.
Thank you, guys.
I'm going to restart this Odyssey and see if it maybe won't buffer so much. It's still not letting me see the case files. Let's see. Let's see, I show Stout on the record in GW 2025 TR 460, State of Kansas versus Amethyst Dawn. Remind me how you pronounce that? Stout?
Stout.
Yes, Your Honor.
Mr. Dean for the state, Ms. Stout in person. Now, you had been appointed William McClendon, but this is a pay or appear date, and the attorneys often don't appear for those. I show you still have a balance of $453. Were you able to pay anything on your case, Ms. Stout?
No, Your Honor.
What's happened? You told us that you thought you could have it all paid by today.
I was recently told to find another place to live, which I have, and I work at nights from 3 in the afternoon to 3 a.m.
Okay, are you able to pay anything on your case at this time?
I will be by the beginning of next month to the middle of the next month.
When do you think you'll be able to pay it all off? $453.
Um,
If I give you another 4 months, do you think realistically that would work or not?
Yes, ma'am.
That's still gonna be $100 and some a month. 111
Yes,
or
ma'am.
so. You can do that?
Yes, ma'am.
Mr. Dean, any objection to setting this out another 4 months?
No, Your Honor.
All right, Missy, can you give me another pay or appear in about 120 days?
Yeah, July, you wanna use that July 17th again?
Sure,
Yeah.
July 17th at 11. All right, I'm giving you till July 17th at 11. Now make sure you start making some monthly payments on that, Miss Stout. If we come back here July 17th and you've paid nothing again, we may have to do something totally different.
Yes, ma'am.
But I understand things can be tough and unexpecteds come up. So do what you can to show a good faith effort at the next hearing if you haven't paid it all off. If you've paid it all off, you don't have to come back.
Yes, ma'am.
All right. Thank you, Miss Stout. You may go.
Thank you.
You're welcome. Okay, let's see. Do we have someone else on here that's failing to appear? The rest of them have all been canceled, haven't they, Missy?
Not Kershaw, I
Oh,
don't.
there's Kershaw. Okay, Micah Kershaw. You have that, Mr. Dean?
I do.
Okay, we will be on the record in 2023 TR 105, State of Kansas versus Micah Lene Kershaw. Paulie Dean for the state. Defendant fails to appear for her review hearing, and this is a pay or appear also, I believe. Yeah, yes. She still owes a balance of $775. Mr. Dean, recommendations? Bench warrant.
Bench warrant. What was the amount?
$775.
That is for bench warrant, cash $775.
All right, if that will be the order, if there's nothing further, we're in recess on Kirchhoff, although why she has a warrant, is that out of another county, Missy? No, that's a Greenwood, different case she has. I show she, well, I don't know how to read that. Missy, am I reading that right?
Oh, okay, on Kershaw, what is it?
Well, I'm seeing the little red W and the case number, it says cross-reference DMV GW DK DKK 7001. I don't know what that is. Is that just
I
something out
don't-
of Topeka?
Where are you seeing that at?
Well, I see the red W up there in the right or in the left-hand corner.
Right.
And then to try to find out where that's out of, I'm just looking down at case cross-reference over there on the right, the third box from the bottom.
Oh, I don't know what that means.
I don't either.
But you want it like that red W?
Yeah.
That's not our case. I don't.
Okay, so that's out of some other jurisdiction. She has a warrant.
I think so.
That's what it looks to me like, but she has one somewhere. Where? Who knows? All right, so
Now
775.
she has another one. A collection you don't want to start.
Ah, okay.
Uh,
Alrighty. Well, that'll be the order, but bench warrant, bond set 775 cash.
so I take it Iona Hill paid then?
Well, let's see.
All right.
I feel paid. And then there was someone above Kershaw that I wanted to ask you about.
That was Hill.
Oh, that was Hill. Okay, that's why she wasn't here.
Then I only have one case remaining, and that's Mr.
And can we
Cooper's
let the
case.
interpreter go?
Yes, sir. If that's why you're back, I thank you so much for your time. We appreciate it.
Of course, Your Honor. Is there anything else I message you with?
I don't believe so. I don't think we have any more defendants, even though we should have a few. I don't think they're appearing today, but thank you.
Thank you, ma'am. Thank you for your services, Your Honor. Have a wonderful day.
You too. And Mr.
Thank you,
Cooper,
Guillermo.
yes. And Mr. Cooper, are you here on anyone else?
He has.
Oh, go ahead.
No, go ahead.
Judge, I'm here on Timothy Fisher, who we have attempted to contact this morning to no avail. would ask for a continuance.
On the record in 2026 TR 53, State of Kansas versus Timothy Allen Fisher. Paul Dean for the state, Blake Cooper for the defendant who fails to appear on one count of driving while habitual violator. Mr. Cooper, you said you've not been able to locate him.
Perez requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Chief Assistant Prosecuting Attorney Victoria Burton Harris.
We're actually gonna let you do things.
Mm-hmm.
Okay, all right, permission to practice is granted.
Thank
Hello,
you. Yeah,
Ms.
you said you wanted to see more of me, so we made it happen.
I did say that, so
did.
I'm glad. All right, Ms. Link?
Yes.
All right. Ms. Link, you are before the court on a felony complaint that alleges that on or about January 1st, 2026, at the location of 725 Manor in the city of Ypsilanti, Washtenaw County, state of Michigan, that you did make an assault upon a Kaylin Lowe by strangulation and or suffocation. Do you understand the nature of that charge, ma'am?
Yes.
All right, that's a felony punishable by up to 10 years, up to a $5,000 fine plus court costs. Do you understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, I do.
All right, this is a public defender case.
Good afternoon, Your Honor. First Assistant Public Defender Kalina Anderson. Your Honor, we met with Ms. Link this morning and she declined counsel, so we did not have an opportunity to speak with her. If Your Honor would allow Ms. Van Blarken to have a moment to speak with her in a breakout room, please.
You want me to give a breakout room?
Yes, please.
Have I ever done that? Fine, Anderson. You know she'd ask. I'm gonna do that. All right, ma'am.
Yes.
Their attorneys came to speak with you earlier today and you declined to talk to them?
Yes, I did. Yes. Yes, I did.
Okay,
I
but you
should've.
want to talk to them now?
Yes.
Okay, so what I'm gonna do is we're gonna put you into a breakout room and let you have an interview with them, okay?
Okay. Okay. Thank
And
you.
then come back out and we'll finish.
Okay.
Please.
Oh, do I only have one room? I've got another guy.
Are you good to just roll?
Well, let me do another arraignment. Pardon? Van Blarken, she ready to go?
I don't know. Okay.
Well, we'll find out. Court does call the case of the People versus James Richmond. Need to unmute him.
Kristen Lewis Perez here for the people, Your Honor.
Thank you.
He's unmuted.
He's unmuted. Sir, what is your name?
James Richmond.
All right, Mr. Richmond. I have two, these are warrants, correct?
Jim has a new felony
Yes, I see that.
and the other two, one is a bench warrant for a retrial, one is a bench warrant for a show cause.
Okay, gotcha. All right. Mr. Richmond, you've got three matters here before the court. You have a new felony case. That felony case is alleging that on or about March 21st, 2026, at the location of 3239 East Michigan Avenue, that count one alleges that you did commit the offense of assault with intent to murder. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony punishable by up to life or any number of years in prison. You understand that, sir?
Yes, sir.
Count two is the charge of assault to do great bodily harm less than murder by strangulation. You understand that charge, sir?
Yes, sir.
That's a felony punishable by up to 10 years, $5,000 fine plus court costs. Do you understand that?
Yes, sir.
Count three is the assault with a dangerous weapon, or commonly known as felonious assault. Do you understand that charge?
Yes, sir.
That's a felony punishable by up to 4 years incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
Count 4 is the charge of the aggravated domestic violence, second or subsequent offense. Do you understand that charge, sir?
Yes, sir.
And that is a felony punishable by up to 5 years and or $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Thank you, Your Honor. First Assistant Public Defender Clena Anderson, with and on behalf of Mr. Richmond in all files, Your Honor, in the 2 new cases, we would waive any further reading. Reserve the bond document.
All right. Defendant heavyweight formal reading standing mute. Court will enter a not guilty plea. I will set probable cause on this matter for, this is the 9th or the 2nd. Say again. April 9th, 2026, 9 a.m. As to bond from the people.
Your Honor, we are asking for $750,000 on this matter. We wanted to ask if you took the testimony on this case and referred to the bond rec form. It sounds like you have all the cases in front of you. So we just want to note that there was a large gap in time with no activity following his plea of torture. Felony assault and unlawful imprisonment is due to prison sentence of approximately 12 years, and that was from December 2007 to 2022, which was a parole discharge. He went back to reoffending very quickly with a DV case in 2025, and the violent circumstances of this offense just from last week. Incarceration has not been a deterrent, and his current probation has not affected the behavior. Right now, the people see this as highly lethal and a huge community safety concern, Your Honor.
Response.
Thank you, Your Honor. There's nothing else holding Mr. Van Blarken in custody Mr. Richmond in custody at this time. He did give us good contact information. In reviewing the charging documents, we see the severity of the crimes. He's not trying to diminish that at all. He's just looking forward to meeting with counsel and proceeding on his day in court. He would ask the court for a personal bond. If the court is not so inclined, then he would just ask for a reasonable bond to ensure his appearance at the next court date, and he would ask for the next available PCC date.
Defendant's bond in this case will be set in the amount of $500,000 cash surety. Although the standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition, or anything designed to be a weapon. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will also indicate that the defendant is to have no contact whatsoever with Lori Ray Williams. That is, do I have my DV form, please? And you understand that, sir?
Yes.
And what I mean by no contact is, I mean that you are not to attempt to have contact with her directly or indirectly, either person or through yourself or with other person's participation. You are not to contact her by electronic communication. That is included in that is you are not to, including but not limited to, by phone, email, texting, internet, social media, and you are not to mention her at all online. I will also indicate that you are not to go to the address of 3239 East Michigan Avenue in Ypsilanti Township. I will order that if the defendant does post bond and if he is released, that he is to be placed on a GPS location tracking tether with the exclusion zone. Do you understand all of those terms, sir?
Yes, sir.
All right. Is there anything further from either side?
No, Your Honor.
Thank you. Thank you on that case. I will also indicate, Mr. Williams, that you are also before the court on a charge on a failure to appear, this being case 252-0702, on a failure to appear at a Is this a show cause?
It's a pretrial.
I add a pretrial. I will cancel the warrant in that case. I will set your bond on that case at a $5,000 10% bond. I'll reset the pretrial for
April 15th at 8:30.
April 15th, 2026, 8:30 before Judge Barr. Then on the case 25F20428. This is for a show cause. All right. In this case, you failed to appear for a show cause hearing regarding the payment of fines and costs. I will cancel that warrant at this time. I will set your bond at an amount of $7,500. I'll give a 10% privilege on that. I will reset the show cause in this case too.
April 9th at 9 a.m.
April 9th, 2026, 9 a.m.
Yes.
9 a.m. before Judge Barr. Right? Thank you.
Another custody.
Yeah, well, the in custodies are coming up. Let me try to get them out. Yes. Court does call the case. People versus Reginald Tucson.
Good morning, Your Honor.
Good morning. State your name, please.
Reginald Matthew Tucson.
Okay. Madam Prosecutor, you want to say?
Jean Louis Perez here for the people, Your Honor.
All right. Mr. Tucson, you are before the court on a felony complaint that alleges that on or about August 5th, 2022, at the location of 375 North Maple Road in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of retail fraud in the first degree. You understand that charge?
Yes, I do.
All right. Because this is a second or subsequent offense notice, and this is a retail fraud first degree, this is a felony punishable by up to 5 years incarceration, a $10,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $10,000, that would become the maximum fine. You understand that, sir?
Yes, I do.
First question I have for you is, do you want to be represented by counsel?
Yes.
This is a public defender case.
First Assistant Public Defender Clena Anderson, within on behalf of Mr. Tucson. Your Honor, we waive any further reading, stand mute, and reserve the bond argument.
All right. Pending having wait for a reading, standing mute, court will enter not guilty plea. Probable cause hearing will be set April 9th, 2026, 9 a.m. As to bond from the people.
Your Honor, we have no problem with a personal bond on this case, or and we would just ask for a no-go to the Plum Market in Ann Arbor, located on 375 North Maple Road.
All right. Ms. Sanders.
Your Honor, as to bond in this matter, we're asking the court to grant him a low cash bond so that he's accumulating jail credits. My understanding from speaking with Mr. Tucson is that he's being held by the circuit court. He has a hearing scheduled on Monday. We did go over the no-go to. He has no issue with that. He will not return to the Plum Market. He'll abide by any other bond conditions set by the court and appear for all subsequent court dates.
All right. I'll set the defendant's bond at a $1,000 10% bond. All other standard conditions, including no assault behavior, possession of weapons or anything fashioned to be a weapon. There's also to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will order it also that the defendant not go to any Plum Market in the state of Michigan. You understand all of that, sir?
Yes, I do.
All right. Anything further? Hearing nothing, thank you.
All right, welcome.
All right, I've got one more in.
She has multiple. They're all arraignments on missed hearings.
They're all arraignments on this. Court does call the case of the people versus Sincere Godwin. Ma'am, can you state your name?
Sincere Godwin.
All right. Or sir, can you state your name? All right. The public defender is representing this defendant on all of these. Go ahead.
Thank you, Your Honor. First Assistant Public Defender Clena Anderson with and on behalf of Assistant Garwin in all three matters. Your Honor, so these are bench warrants for a pretrial on the misdemeanor matter March 18th and probable cause yesterday on the two felony matters. Your Honor, my client was in custody in the Wayne County Jail from March 9th to March 27th. He was brought here directly from Wayne County. Given that, Your Honor, I would ask that you grant personal bonds and reset the hearings in all cases.
All right. So on the just released from Wayne County or brought here from Wayne County?
Brought here from Wayne County.
Okay. All right. So in the felony matters, I will cancel the warrants and reset the defendant's bond to the previous bond with its conditions. I'll set probable cause conference in those matters for April 9th, 2026, 9 a.m. Got that, Mr. Godwin?
Yes, Your Honor.
And then on the misdemeanor matter, this is my case. I'll cancel the bond. Reset his bond to personal recognizance, $5,000 bond. And I'll reset the hearing. I think we're set for pretrial in this matter. To reset pretrial in this matter to April 1st, 2026, 9 a.m.
Thank you, Your Honor.
Have a right to have the case heard here in St. Joseph County where the property is located. That's never been an issue, but the Supreme Court tells me I must advise you of that. You have the right to demand a jury trial. If you want to have a jury trial, you must tell me at this first court appearance, or be prepared to make the demand for a jury trial within 5 days of today's date in writing using the jury demand form, and pay the $50 fee that accompanies the demand for a jury unless the judge waives the fee for your inability to pay it. If your landlord asks you to be evicted from a residential property because you haven't paid the rent, you may be eligible for some emergency housing assistance from Department of Health and Human Services, Community Action Agency, Keystone, or a veterans program if you are eligible.
Sir,
If
may I
they've
interject?
asked to terminate your tenancy and simply have you vacate, that's a different circumstance. But I think both of these are demands for rent. You may be able to reach an agreement with the landlord by going through mediation. So far, that's never happened, but it might. If it does happen and the matter is resolved, that could be a way of taking care of it. In addition, the parties may reach an agreement. There's Meg now.
Your Honor, may I interject real quick? We don't think
Yes.
there's a point in going forward because Alexis had vacated the property and
All
given.
right, well, we'll get to
notice.
your case in a minute. Ms. Bauer is joining us and the attorney isn't here yet, and I'll certainly hear what you have to say when we get to that matter.
Thank you, sir.
You may be able to reach an agreement with the parties that would result in a conditional order of dismissal. If that happens, Mr. Nossinger could prepare that order or someone else. Meg Bauer just joined us. Mr. Frederick, this is a property on South River Drive. Your landlord contends that the rent is in arrears more than $4,000, probably $5,000 at this point. Luke, what's the arrearage here?
Yeah, the total amount collected, this includes anticipating rent for tomorrow that would be due. Tomorrow, Judge, is $4,910.
That's through April?
That is through tomorrow.
All right, through March 28. All right, what do we have for costs here?
I have the $55 filing fee, statutory $75 attorney's fee, and then the service fee of $37.10. Judge, I have a proposed judgment.
Oh, very good, thank you.
I was reading off of it, and I thought I would give it to you. And that the total cost is $167.74.
All right, now, Mr. Frederick, I need to disclose to you that I know the Trammels. They're friends of mine. I belong to the same service club as Mrs. Trammell. They live across the lake from where I live, and I see them regularly. I see Cindy or Christy Trammell at least once a week. They do not regularly appear in my court, but maybe they have as a landlord from time to time. I don't feel the need to disqualify myself, but if you're uncomfortable with that, I could have this matter assigned to another judge. Mr. Frederick, it's acceptable to you that I handle this matter? You need to unmute your mic. Mr. Frederick, I can't hear you. Our defendants are stacking up. You're okay, soft now. Can you hear me now?
Yes, I can hear you now.
All right. Are you uncomfortable on me handling this matter because I know the Trammels?
No, Your Honor.
You don't have any objection to that?
No objections.
All right, what's your position? You're substantially behind in the rent. Do you have any plan to pay this, or you plan to vacate?
I plan on paying it, Your Honor. I just sent out a form for the SER.
How do you plan to pay it?
I just got a job last week, Your Honor.
Where's that?
Fiber converters.
That's ironic. Well, are you going to receive a tax refund?
No tax refund.
Mr. Knopfinger is aware of this. The law requires I adjourn this matter at least 7 days for you to have an opportunity to seek legal advice. This is a big giant arrearage, and your first paycheck isn't, we're going to add another month's rent to this when we get into April. It's going to be north of $5,000. And they're not just going to give you a $5,000 check. The only thing that would actually pay this is paying the entire amount of rent. Now, the Trammels can agree to work with you on some sort of repayment protocol, but this is a big arrearage. So today is the 27th. Next Friday is April 3rd, and that's a holiday for Good Friday. So the next day I have available is the 6th. And we got a big gap, Luke. Darn it. Eesh. Gonna be a rough go when we get to April 6th. Oh boy. How are you for 2/15 for April 6th?
I can do that.
Does that work for you, Mr. Knopfinger?
You said April 3rd.
April 6th. April 3rd is a holiday. The courthouse is closed.
It's Good Friday, that's
Yeah.
right. Yes, 2:15 will work.
We lose either due to holiday or vacation, 1, 2, 3, 4, 5 of 8 landlord-tenant dates in April. So April's going to be a bumpy ride, and the 6th is going to be very full.
All right. Mr. Frederick, you are free to discuss this matter with your landlords in some sort of a plan to catch this up. But the only thing that will cure this is paying the entire amount of the rent. And there's going to be another rental period due when we meet again on April 6th. So that's 10 days from today. What would happen at that time is you would either have to pay the rent or be compelled to move within 10 days of that date, which would entail an eviction where your sheriff comes and puts your stuff out. Your landlord does not have to evict you on April 16th. They have 56 days from that day to seek the writ of eviction. So that's actually 10 days to April 6th, 10 more days to April 16th, and then they would have 56 days from April 16th to ask for the writ. So there's some time in here, but they have people waiting to rent this. They have a waiting list. And if they're not going to be able to redeem it, they just need to get you out and get somebody in that's going to pay the rent. So you guys can discuss this further, but we will continue the matter because the Supreme Court says I have to continue it at least 7 days. We're going to adjourn it to April 6th at 2:15, and we'll discuss the matter further at that time.
Two things, Judge, if I may. The lease didn't indicate exactly what portion of the property he occupied. We understand that he's in room 2.
That's what it says here, room number 2.
We're not expecting to evict all other occupants. That's just boilerplate language from my perspective. The other is my clients are willing to, if he's able to secure funding some other way, I'm willing to work with that organization, but we are expecting full amount.
Well, I did mention that, Mr. Frederick. There's the Department of Health and Human Services, Keystone, Community Action Agency. Those are all agencies that have some funding that may be able to assist you. So let's say for the sake of argument, you get $3,000 worth of emergency financial assistance. You would still owe $2,000.77. You have to pay the entire amount to carry the writ of eviction. So there's a lot to discuss, but I would suggest you contact those agencies that we sent you with the summons about who is got funding. Unfortunately, there isn't enough funding to go around. We got more demand than we have supply when it comes to emergency financial assistance. But your rent is substantially in arrears. It does not appear to be subsidized. So you could be eligible. Have you talked to any of those agencies?
I talked to Keystone. If they don't do that no more.
Well, I would contact Neighborhoods Inc. and DHS, which are in there.
Okay. I got
All right.
for DHS.
Say that again.
I got a SER out for DHS.
All right. So you have started. Ultimately, if the rent is not paid at the discretion of the landlord, they could compel you to move 10 days after our next hearing on April 6th. So good luck, sir. I'll see you then. Mr. and Mrs. Trammell, you have any questions?
No, sir.
All right. Thank you, Luke.
Thank you, Judge.
Mr. Frederick, I'll let you go on about your business. Same with the Trammells. All right. Thank you. They're gone. All right, next up is Edgewater Place versus Conley. Mr. John Bradshaw is here on that matter.
Your Honor.
Mr. Artley, the manager. And I'm going to remove this. Oh, wait a minute. I lost her. Where'd she go? Alexis Conley. And Cindy, what's your last name?
My last name is Gardner, sir.
What was it before?
It was Foster when I was in high school.
All right.
Couple of
We
years.
won't say
behind.
we won't say how long ago that was.
No, sir.
About 10 years ago, give or take. All right, in the meantime, let's pause that matter for a minute. Mr. Hintz and Ms. Westcomb are back. Mr. Hintz, did you reach any progress in discussion?
Your Honor, we've been talking and we've worked, we're gonna come to a resolution or a number very soon. She's gonna get me some information. I'm gonna send her some information. So we're talking, Your Honor. Ms. Westcomb and I just wanted to let the court know that we were talking. We know how to reach each other. We have emails and phones, so we should be good.
All right, very good. Ms. Westcomb, do you have any questions?
No.
All right, you're free to go. Thank you, Mr. Hintz. I'll see you again.
Thank you, Your Honor. I'll get the paperwork in. Thank you, sir.
All right, Ms. Westcomb, you're free to go. All right, then let's go to Edgewater v. Conley. John, while we were doing the previous case, we've advised these defendants of their rights. I just received a email from Cindy Gardner indicating that Rachel Conley will not be present. So this is a River Drive apartment, 26384 LT. It's a non-payment of rent case. Did you guys get tornado damage?
Yeah.
Alexis?
Yes, we did.
I mean, did you get damage to your unit?
I think so. I don't.
No,
No.
sir.
No.
All right. So, all right, well, let's start with how much is due. Mr. Bradshaw, what's the arrearage? John, you're on mute.
Sorry about that, Your Honor. The amount that's needed through the month of March, can you hear me now?
Yes.
Okay, great. The amount of rent is $2,053. There's $221 in court costs, so the total due is $2,274.70.
All right, now, if I understand correctly, Alexis, both you and Rachel have vacated the unit?
Yeah.
Well, Your Honor, we've only asked for, we did not ask for a money judgment. So if they're stating right now on the record that we can have possession of the unit, I'll just confirm that with Daniel, and then in the next day or so, we'll be filing a dismissal.
All right, Alexis, have you got all your property out of there?
No.
Oh, all right. That changes things.
So if I may interject, sir,
right.
I believe Lexus.
How are you connected to this?
I am the aunt and great aunt, and I'm here to support Alexis. Alexis stuff is primarily out of there. What is left is some of Rachel's belongings, and we'd like the judge, if possible, to give her time once she's dismissed from the hospital to get her things out of there. But she is more than willing to vacate, and Alexis vacated last year.
What, ma'am, will she need more than a week to get her stuff out?
Once released from the hospital, I don't believe she'll need more than a week.
No, I meant a week from today. So is she in the hospital because she has an injury?
She's in the hospital because of a mental health issue. So we don't have a lot of details, and we don't have a discharge date. But I know Alexis cares about her mother and would happily participate in moving things out.
All right. I appreciate your being here to give us some context. Alexis, where do you live now? Don't tell me the address, but what town are you in?
Three Rivers.
All right. When you move, you're supposed to give your forwarding address in writing to the landlord within 4 days of your moving. You're still on this lease. Mr. Bradshaw is looking towards maybe some sort of consent order or a conditional dismissal order. But right now, we don't know what Rachel's status is, if she's presently able to make these decisions or if she's going to be discharged. So, John, I think the safest bet is to continue this to April 6th.
Yeah, I saw that you were doing that to April 6th. Is there a chance that we could do that in the afternoon?
Yes.
Okay, great.
It's going to be a very busy afternoon, but that's what we get paid for.
Sure.
$9 an hour works out either way. How about 1:30? I'm looking to see if you have anything here that day.
Not we
I don't see that you have anything. How about 1:30 that day?
Okay, that sounds great. And then, Your Honor, is it possible? So, is there a contact I can get, Ms. Gardner? I mean, do you have a? Can I keep?
Let me put the three of you in a breakout room.
Okay.
Good afternoon, gentlemen.
And I have one more at one more. Guess what? LLC versus Hector Torres, and I see they're there.
All right. All right, stick around for a minute. We'll do this next matter, and then I'll let you talk to Mr. Bradshaw, so you can get a little bit of a more legal education watching our proceedings. Gentlemen, which case are you guys here on? I have Singh and Harris. Oh, here it is. Borgard Family Farms and Peck. Yep. Okay, welcome. All right. Mr. Torres, would you join us, please? Now I've got Carrie Harris. We're going to talk to her. We've got Simran, that's Mr. Singh. We got Hector Torres. Mr. Singh, you need to take off your hat. And we got somebody that's just a telephone number. Who's here by, you can leave that on, your cap.
I'm Vanessa Lozada.
All right, no, take that hat off.
This one? All right.
All right.
Vanessa Lozada, I'm on the phone call.
All right, what's your name again?
Vanessa Lozada.
He's co-defendant with Mr. Torres.
With Heck, yeah.
Vanessa Lozada.
Yes.
All right, Ms. Harris, Mr. Torres, Ms. Lozada. You are tenants in a landlord-tenant proceeding. As such, you have certain rights. You have the right to hire a lawyer. If you can't afford a lawyer, you can ask if legal aid would represent you or seek other legal representation. Our legal aid attorney is here with us on the live feed. Her name is Meg Bauer. She's a very experienced landlord-tenant lawyer. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file a written demand within 5 days of today's day and pay the $50 jury demand fee unless you're unable to pay it. And the judge could waive it. If your landlord has asked you to be evicted because you haven't paid rent, you may be eligible to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, that would be Neighborhood Inc. Or if you're a veteran, you may be eligible for some veterans housing benefits. You do not need a judgment against you to receive assistance from those places listed above. Copy of the summons is sufficient, and you already have that. You may be able to reach an agreement with the landlord by going through mediation, local community dispute resolution. It's sometimes referred to as. Or you may be able to reach an agreement with the landlord that would result in a conditional order of dismissal. This matter is filed as a demand for non-payment of rent. Rent is $9.75 per month. Mr. Bradshaw, what's the status here?
Your Honor, the current amount due through the month of March is $2,175. There's $238.45 in court costs, so the total due through March would be $2,413.45.
We had the money. I did money orders yesterday or this morning because Walmart was closed yesterday by the time I was able to make it there after work. I think it was $2,500 that we just put in the mailbox of the apartment complex for them, which hasn't been entered in yet into
Very
the
good.
system. And I can get the other rest of it.
All
I think
right,
it will
well,
be like
$2,413.45. If you put $2,500 in there, you've paid the rent.
Yeah.
Yeah.
Now,
I
what we're
did
gonna
that
do
today,
is we're gonna
though.
adjourn this to next Friday, or to Monday the 6th. Continue to April 6th, 2026 at 1:31. That'll just make it a different bracket. If the rent is paid, the matter can just be dismissed. Of course, April's rent is due on April 1st, but it sounds like you're good. If you put $2,500 in money orders, that should pay your rent through March plus court costs.
Yeah. They also just put in for what is it? For April. So I'll be getting that as soon as I'm out of work today.
Very good.
Yeah, it was just a matter of me getting out late and not having the time to rush over to get the money orders.
All
So
right,
I'm
well,
handling
I'm
it.
gonna set this for another hearing because I have to. But if everything is paid, Mr. Bradshaw will just dismiss the case. So stay in contact with your manager.
Yeah,
And,
I have
let
been
them
trying
know.
to, and they haven't been answering me.
So what
I've been calling, texting, and emailing, and I haven't gotten any responses back since I want to
No
say
one's
like October.
managed company here today.
What I will do, Your Honor, I will confirm either today or Monday at the latest, confirm the money's been paid. If it is, get a dismissal in, so March is done, this case is done, and you won't have to come back as long as you get that dismissal, ma'am.
Okay, I'm sorry again. Thank you guys.
All right, you don't need to apologize. All right, hopefully this will be dismissed and I won't see you on April 6th. All right, Mr. Torres, I'm gonna remove you.
Okay.
April Lozada, I'm gonna remove you, or Vanessa Lozada. Then I'm going to set up a breakout room for Cindy, Alexis, and Mr. Bradshaw. Mr. Artley left. He's still here. I'll put him in it too.
Okay, great.
I got a guy that's listed as being in the room, but he's not. I can't get him out of it.
We'll kick him out if we see him in
ignore
there.
Jimenez Gonzalez. Anyway, I'll assign Alexis to room 1. I'll assign Cindy Foster to room 1. I'll assign Jan Bradshaw to room 1. This is similar to Purgatory. And I'll put Mr. Artley there as well. All right, everybody hit the button that says join and you can discuss things in the meantime. I'll be here. All right. Next up is Simran Singh versus Carrie Harris. This is filed as a termination of tenancy matter. Notice to quit. Was February 16th. This is apartment 1. Mr. Singh, am I correct? You're simply asking that she move out?
Yes, Your Honor.
Ms. Harris, what's your position?
My position is there is no place for me to go.
and I was paying my rent up until our last court date that we had, and they refused to meet with me and go over things. So I'm kind of stuck. That's my position. I don't know. I've put applications in. I've tried to get help from the state. There's nowhere for me to go. And I'm willing to pay my rent, but they refuse to meet with me to go over paperwork of things that I have that they don't have.
Once they file a termination of tenancy, they can't accept rent. So he doesn't want you to pay, just wants you to move. I didn't look up the previous case. I think we got sort of halfway. Who else is there? It's Carrie Harris and all other occupants.
Chuck.
Who else is there?
There's one more guy, Your Honor. I don't know his name. Chuck?
Chuck Shaddix.
He lives there also?
Yes.
Is he on the lease?
No. But they knew he was living there.
Now, the law requires that I adjourn this matter at least 7 days. I'm going to continue this to April 6th. I can't adjourn it to next Friday because that's a court holiday. And we'll make it at 2:20. Ms. Harris, if Mr. Singh gets what he asked for, you and Chuck are going to have to move out 10 days after April 6th. He's not asking you to pay money. He's asking you to vacate. You've got an unlawful tenant in there, which is an additional reason why he wants you to move.
Unlawful.
He has filed for money damages, I think. Nope, no money damages.
That was the last time.
So this is simply a possession issue, not a money or rent issue. Once you move out, if he does seek money damages, we can have a hearing where people are sworn under oath and I take testimony about who owes who how much money. Calculate if there's a security deposit, how much rent is there, that sort of thing. At this point, he simply wants you to move. This process is for people who can't move, because otherwise they would never move. There aren't enough places to move to. There's not enough housing, period. And there's certainly not enough affordable housing. But the landlord doesn't have to be compelled to have you stay there. So the sheriff comes and puts your stuff out in the street. That's not a very good solution. So I'm adjourning this matter 10 days till April 6th. You get an additional 10 days from that day to vacate or be subject to being evicted. So the target date for you to look at to be out by would be by April 16th if he gets what he asks for. Do you understand?
Yes, Your Honor.
Do you have any questions?
No, I guess not. I mean, I've got paperwork and everything. I don't even know why this is going on because I paid my rent. But
well,
I've been there for 4 years.
He's not asking you to pay the rent. He's asking you to move.
That's the whole reason why he took me to court. Supposedly, if I have a $500 water bill that I never got a copy of, how is this all fair? I don't get it. I've been there for 4 years.
Mr. Singh, when was rent last paid?
Your Honor, she paid me right here. She paid me $550 in January. She paid me $250 in December, and she haven't paid me her balance of $450 in January. Nothing paid in February. Nothing paid in March. And she
that's because you stop. That's because you filed a termination of tenancy.
Absolutely right.
So
absolutely.
it isn't though she wasn't willing to pay it.
Yeah, and
but
then
once you file a termination of tenancy, you can't accept rent. So I was just wondering if she was like thousands of dollars behind in the rent.
No. It's not like that. Your Honor, it's just that she doesn't communicate. I mean, and then I just want my property back. It's just so many years. So yeah, I just request to get it back.
Your Honor, I have text messages that I have them telling me no more talking. I just want my house back. They don't send me the. How am I not talking to them? They refuse to meet with me, and that's why.
Stop. Is there a lease in effect? There was no lease filed with this.
There is a lease.
From when to when?
I'm on month to month. I've been in there
Yes,
for
that's what
4
I
years.
thought.
Yeah. And I haven't paid rent since the last court date because they refused to meet with me and go over
That's
things.
correct. You're not supposed to. All right,
Okay.
it doesn't have to be fair. He's the landlord. You have a month-to-month tenancy. He gave you more than a month's notice to vacate. You didn't vacate, so he filed the case. So he's asking for his property back. Let's say he wants to move his brother-in-law in there, or he wants to empty it so he can refurbish it, or he wants to empty it so he can sell the building, or he wants to empty it so he can tear it down. This is the process you go through to do that. When you have a month-to-month lease, you don't have indefinite right to the premises. You have a month's notice, and then it starts this process. So he served a notice to quit on you, and
I know, and I have nowhere to go, Your Honor. I mean, where am I?
all right, and that's not uncommon. There is no, I have nowhere to go and exception to the fact that I have to make a landlord keep somebody as a tenant they don't wish to have. So you can consult with legal aid. They're here.
I have.
You can
I've already got a hold of the
hire a
insurance.
lawyer, or you can prepare to vacate. But we're going to continue this matter to April 6th at 2:20.
All right.
All right, you're good to go.
Thank you, Your Honor.
Okay.
Next up is Legacy NWI LLC versus Sarnacki. It is a landlord-tenant matter. Have received a dismissal from Mr. Bradshaw's office without prejudice, and I'll sign that. Now, what time is it? It is 1:48. I have before me a consent order for conditional dismissal. Let's address that one, and then we'll see where we are with our other stuff. Got Mondays. Which case are you here on, Luke?
Judge, there was a continued debtor subpoena.
Yes, there is. That's set for 1:45. Let me take care of Luke's, Lance's matter.
Sure.
And I will, I think I might have just removed Mr. Bradshaw accidentally. The column skipped. I went to remove Mr. Cimarron. Be with you in a minute, Lance.
Okay.
Yeah, that's Perez Harvesting. It was set for 1:30. Did anybody show up?
There was no one in the hallway, Judge. I can go check.
All right, we'll make a record on that in a minute. All right, I guess everybody left in that other case, so perhaps they got as far as they were gonna go.